Lord, I may be part of
of to comply with the order dated 18/1/2023.
What was the direction?
The direction was to deposit rupees 10,000 rupees before the learner DRT within a week to accept the counter affidavit, counter written statement in defense for the petitioner.
It was a conditional direction.
Yes,
It
sir.
was a conditional direction.
It was
We are of the opinion that keeping the matter pending before the it serves no purpose. Pending since last 11 years before DRT, Kotak filed by the so-and-so. To serve the ends of justice, we modify the order passed by the DRT Kotak to the extent that the present petitioner defendant before it shall deposit 10,000 within 1 week. But this order was passed way back.
he doesn't deserve. He doesn't deserve indulgence. That's also correct.
Right, this was passed way back. And direction was to deposit 10,000 in the remission of the amount already there by the DRT.
yes, sir.
So,
Your Lordship, due to health issues, the petitioner couldn't deposit the
no, your application, come to your application now.
Yes, sir.
Where is your application for extension? Flag A?
Yes.
No. Where is your application?
Flag B, madam. Not flag B.
At flag B, where is that B? A we found, then flag 10 also we found. ଅଛି ଆପଣଙ୍କ ପାଖରେ ଅଛି okay probably it is here ନାଇଁ ତାର repeaton ପୁଣି then the chief justice
3698. 3698.
ନାଇଁ ତ ମୋ ପାଖରେ yes where is that application ଆପଣ କପିରେ କଣ ଲେଖା ହେଇଛି ଦେଖିଲେ ପ୍ରେୟାର ଟା କରିକି ଲେଖିଛି ପ୍ରେୟାର ଟା ପୁରା ପ୍ରେୟାର କୁ ପ୍ରେୟାର ଟା then the previous order restores back. Then the previous order restores back. You were directed in the month of January for depositing the remitted remission amount.
Yes, yes, Your Lordship.
So if you were in need of 1 week, then you should have come in time.
As the
Sorry, then if you fail, then the order revives.
Due to some health grounds, the petitioner couldn't appear
Pardon?
within the. Due to some health grounds, the petitioner couldn't appear before the learner DRT within the 1 week. That is why, Lordship.
You have not followed. You have not followed what fell from my lord. On 18 January, the order is passed.
Yes, Your Lordship.
You wait till 17th of March,
Because
and court has shown you enough indulgence. This matter was lying for 10 years, and it was a cost of 2 lakhs. So you don't deserve indulgence. Actually, you are just abusing the process of court law. Just abusing.
I bow down to Your Lordship, but
What is there to be bowed down before the lordship? You neither you are before that 7 days.
showing even your readiness.
Your Lordship, we are ready to pay the rupees 10,000.
Then you should have deposited and come here.
How much more you will pay?
You
Because
volunteer. You volunteer.
you
because
volunteer.
There is serious negligence and we can't just simply ignore all these defects. It's a serious negligence. 2 lakhs has been brought down to 10,000 within 1 week and you did not pay. Even within 1 week, you did not sought for extension. You are coming to High Court after 2 months for extension of 1 week. Even if we extend 1 week from the date of order, that also lapsed. Therefore, we'll impose further cost on you to have a check on this attitude.
Your Lordship will comply this within any time frame as Your Lordship wishes.
This court, this is an application for extension of time filed on. So
Mr. Udgata, you have to say anything? Please unmute.
Previous minutes.
Sorry?
As you see previous minutes. As you see previous minutes.
Okay. Well, for extension of the petition seeking extension of time frame in order dated 18/1/23 by another 1 week by filing such application on so and so date. It is unfortunate to note that the final order dated 18/1/23 was passed, taking a lenient view, thereby reducing the direction of the TRT dated 19/6/14, accepting the written statement subject to deposit of 2 lakhs to rupees 10,000. This amount was directed, reduced amount was directed to be deposited within 1 week of the order. And the acceptance of written statement was subject to such deposit. There has been no application within 1 week, expiry of 1 week even. Application is filed on so and so and moved to Deajirodogo. In the process, this court find there has been already lapse of nearly 4 months. More than 4 months. More than 4 months. Sorry, May gala na? January. 18/2, 18/3, 18/4, more than 3 months. This court find there is serious negligence on the part of the petitioner herein. However, since there is already an order in the reduction of the amount assessed by the DRT, but while also keeping in view to check such negligence, check recurring of such negligence, this court imposes a sum of rupees 10,000 as additional cost. And this additional costs shall be deposited in the District Red Cross Fund with the collector Cuttack. This court, in partial modification of order dated 18/1/23 to the above extent, further also direct, in the event there is no deposit of the sum of rupees 10,000 as directed by this court in order dated 18/1/23, the order of the tribunal 19/6/14 shall automatically revive. Yes, with this observation, the writ petition stand disposed, the miscase stand disposed. On deposit in the Red Cross Fund, be submitted to this court within 7 days.
You are the
My
counsel who
appearance
appeared earlier on 18th of January.
Yeah.
You are the counsel.
Yes, Your Lordship.
You appeared on 18th of January.
Yes, Your Lordship.
Mr.
That's my
Udgata,
appearance.
Be careful, be careful. Appearance note kar dabo Vivekananda Udgata.
Obliged, my lord.
Yes.
For admission item number 2,
None appears for the petitioner when the matter is called. Matter is pending since 2015. Dismissed for non-prosecution.
in item 3, memo has been filed for order.
Okay. There has been filing of memo by learned counsel for the petitioner seeking withdrawal of the writ application. The writ petition stand dismissed as withdrawn. Memo so filed be kept on record.
Item 4,
May I please, your lordship. Lordship, I'm appearing for Mr. A.K. Mahapatra. We haven't received any instruction, lordship.
Okay. Your name, please?
Saurabh Das.
Mr. Saurabh Das appearing as proxy counsel on behalf of Sri Alok Kumar Mahapatra. You file a memo indicating that.
Indeed, lordship.
Files a memo indicating that he has no instruction from the counsels have no instruction from the petitioner. Thus the matters, the memo be kept on record. The matters can dismiss for no instruction.
Hello, lordship.
Opposite party kya achandi?
As for the intervenor, that's an infructuous matter.
Intervenors only. Yeah.
item 5,
My lords, I am appearing through virtual modes as I am not well today, my lords. In both the connected matters, item 5, I have filed 2 IAs for substitution of SAHOO, opposite part number 2 and 3. Those IAs have not come on record, my lords. IA number 4457 and 4456 of 2023.
Now let
No,
us
no, kindly go one by one because
let
it is
us
not been
go one by
traceable.
one.
One by one.
So WPC 8537, what is the miss case?
IA number 4457 of 2023.
It is submitted by Sri Janna appearing on BC that in the meantime for there is change in the ownership at OP number 2 and 3.
My lords.
There has been filing of IA 4457 of 2023, not on record. Registry directed to bring such application on record and place the matter again on in orders on Monday. Again on Monday. A second case, what is the read number? WPC 18465 re kon karchandi?
That is IA number 4456 of 2023.
Okay. Next case is empty order kariyo, but IA number 4456 of 23. Okay.
Obliged.
अच्छा ये तो काहे के press here आएगा. Suppose okay, let the council decline to appear. ताहले हमें notice करिवा. बहुत opposite particular notice करिवा. Yes. You also saw, Mr. Janna, you also saw copy of the bis case on the appearing councils for such parties. Okay, so that if they have instruction to appear, it is better.
I have served my.
SC Das को ऊपर दे दियो हम लोग.
Again, the
Yes, item 6.
item number 6,
My lord.
My lord, IA number 14818 of
Please be on mic, Mr. Mahanti. How to गुंची जान तो अपना right को how to गुंची वाले हाँ.
My lord, IA number 4818 of 2023. That is filed
IA number
4818 of 23. Substitution
that is
petition?
for replacement of petitioner,
Yes, yes.
but that's not on record.
My lord, that is filed on 3/4/23.
Okay, it is stated by Sri P. Mahanti, Learned Senior Counsel, assisted by Pranay Mahanti. There has been filing of application for bringing application, seeking bringing in the new parties in position of petitioner. By DIA number 4818 of 23. Registry directed to place the miscase on record on next listing on Monday.
Wednesday, Wednesday,
Pardon?
Wednesday.
Wednesday,
Ah, yeah.
all right, Wednesday. These are old matters, so we may be.
नहीं actually ये matter
Dispose of.
किसी नहीं challenge रो खाली I would have said that without recording my concession, Lordship
Okay,
would have
okay,
decided.
then let the miscase come.
Say
and-
that was the transfer from Mr. Naik, Vasant Naik.
Okay, all right.
Item 7,
My lord, in this matter also filed the way on IA number 4668 of 2023.
488 of
466
4
466 of 668
668
आ गया
Okay.
of 20.
of 23.
Okay.
Okay, here also, है same order, but miscase number change कर दो 466 of 8.
I am appearing for the,
Yes, Mr. Das is present in court, senior counsel, present through VC. है ना? The same order. Next Wednesday.
এটা 17 को रखो 17 तारीख
17 ରେ ଆଉ କଣ ହବ court?
ନାଇଁ 17 ଆଜ୍ଞା ମୋ
ସେ ନଥିବେନି, ସେ ବାହାରୁ ପଳେଇବେ।
ଆସିବ ନହେଲେ ଛୁଟି ପରେ ଏଟା ହେଭି ମ୍ୟାଟର ଟା ଟିକେ ଟାଇମ ଟେକିଂ ହବ
Heavy matter, ଆପଣ ପାଇଁ କଣ heavy?
ନାଇଁ ଆଜ୍ଞା ଏଟା 160
We will learn something.
ଟିକେ ଟାଇମ ଟେକିଂ ହବ ଟିକେ ଲର୍ସିପ I humbly pray.
All right, considering there will be, Sri Das will be away from state. This matter is directed to be.
in the last week,
Okay,
last week,
ଶୁଣନ୍ତୁ miscase ଟା ଆସିଯାଉ।
ଆଜ୍ଞା
ହଁ ମିସକେସ୍ ଟା ଆଜି ଯାଉ ତାପରେ ଯାହା
Miscase regularize କରିଦବା।
ଆଜ୍ଞା
ଆଜ୍ଞା
So
ଆଜ୍ଞା
that
ଆଜ୍ଞା
Sri- So
ଆଜ୍ଞା
that Sri Das moves with the fees.
ये आगे यार सेकंड कैरियर नंबर ऑफ रिक्वेशन नंबर ऑफ सीनियर
Next Wednesday for orders.
आगे
Next Wednesday for orders.
oblige oblige
ତାପରେ ଆସିବ ଛୁଟି।
आगे
ଆଜ୍ଞା ଆଜ୍ଞା ଆଜ୍ଞା
ହୁଁ।
already
ହଁ 8 adjourn ହେଇଯାଇଛି, right. ଆପଣ ଆସିବେ।
item 9,
नहीं जा
May,
Yes, 9.
May. I have checked. I filed
It's a labor dispute.
Madam?
It's a labor
Labor.
dispute. All right. Argue. Oh, counter affidavit, what is the challenge here?
My lord, I am the petitioner, my lord. I am
Huh?
challenging the order dated, letter dated 7/12/2022, my lord.
Annexure,
Annexure 1, my lord.
who are you? You are
My
the
lord, one of the
union,
union, my lord.
employees union.
My lord.
Notice is already served.
Already served,
Yes, Sangram Senapati is there.
Already appeal.
my, may,
The election, I have filed the counter affidavit, my counter affidavit. Annexure.
Please, put your mic on.
Yes,
Switch on कर दियो
that I have filed my counter where the
my lord, I will,
petitioner
first I will.
What is your
contested
instruction?
election.
If you have- What is your instruction if you have participated in?
No, no, my lord, we have not participated. Though, your lordship, may I place the?
is admitted
Yes,
that there is internal dispute between
No, no,
them.
that
Mr.
is not-
Tripathi, yes, we accept that you have not participated.
My lord,
Can we direct holding of another election?
yes, my lord.
When?
And,
So under which provision?
my lord, he has not followed the recognition of trade union.
No,
rules,
that's
my
not that's not the query from the court.
My lord,
You see, Mr. You are Z, XY participated. Results have declared. Now Z comes and says that since I did not participate, let another election be held.
my submission, it is not
No,
that.
no, so,
I-
no,
my lord.
that can't be your submission.
My lord.
Factually, if you deny that yes, election was not held,
Election was held, my lord.
XY did not participate, result was not published, then you start, that should be your starting
My
submission.
lord,
So what is that?
My,
what is more
my,
left
my
here?
submission, my lord, he has arbitrarily deleted 15 numbers of name, my lord.
Pardon?
15 numbers of name
Come
from
to
the,
Annexure 1. What is Annexure 1?
my lord, annexure 1 is the notice of election, my lord. On
Of
the
verification of membership.
my lord.
ଏଇଟା କାହାକୁ ହେଲା notice?
My lord, all the
Unions,
my lord, unions, my
all the unions.
lord.
Where do you find that?
My lord, from the last, my lord, copy along with the copy of the final voter forward to the general.
Jayashree Chemical Employees Union is also noticed.
My lord.
So who are you?
My lord, I am the Jayashree Chemical Employee Union.
You are also noticed.
My lord, notice.
So what was your
My lord,
grievance?
after getting notice, my lord,
Hmm.
since he has deleted 15 numbers of voter list, my lord,
Hmm.
from the, we have submitted an representation before him, my lord. And
Yeah, there are the verification of membership rules there. Let us see the procedure. Just 1 minute. Just 1 minute. There is a specific provision for
Yes.
raising objection.
my lord,
The draft voter list must have been published.
the draft voter list not published, my lord.
That you say.
Not their counter also. Their counter, the labor, the returning officer also filed counter that he has not published any draft list. my lord.
Verification of membership rules what achi industrial tribunal dispute act. ଆଉ ଗୋଟେ ଦଉନା ଏଇ ବହିରୁ ଗୋଟେ ଦିଅ ଦେଖ। Please come to the verification member rules.
My lord.
Tribunal act ର ପଛକୁ ସେଟା ଥାଉଛି ହେଲା।
Your lordship, chapter 3, rule 10.
Yes.
My lord, relevant is, my lord, 11.
Yes, come to chapter 2, rule 5.
My lord,
Yes, state implementation officer and
Evaluation officer.
and evaluation officer. Read that.
my lord, it shall be duty of the state implementation and evaluation officer, my lord, to receive application and examine such application of unions to recommend for grant of recognition by employer, and for that purpose to pass for taking ballot for verification of membership of the unions for recognition by the employer, to appoint the returning officer and polling officer, to conduct verification of the union membership by secret ballot for the purpose of recognition by union by the employer, to notify to the parties concerned the result of verification of union membership and advise the employer for grant of recognition to the union, to recommend cancellation, recognition, union or basic of complaints, breach or code of discipline or on unfair labor practices and other terms and conditions of recognition after giving the parties an opportunity of hearing.
So where is the provision for receiving
My lord, 11, my lord, rule 11, chapter
in
3.
case of multiple union?
My lord,
Hmm.
in case of multiple union in an industry where application in form A, in case of unions and form B, in case of employer prescribed under the rules in triplicate along with the prescribed fees have been received by the state implementation and evaluation officer from any of the unions or the employer, and after preliminary inquiry, if the union is found to be fulfilling the criteria for recognition, he shall order for verification of the union member fees.
So where is the provision for preparation of voter list?
My lord, 3, my lord.
Pardon?
That 11(3)(a), my lord.
Yes, 11,
3(a),
3A.
my lord. The returning officer shall collect the names and particulars of the employees working in the industry and establishment, and shall display the same in the notice board of the employer union, and also forward copies to all unions, inviting objection, suggestion within a period of not less than 10 days.
So
Then-
your allegation such a list has not been circulated?
No, my lord. Second,
Where is your allegation? Where is your allegation in the read? that there is no public circulation of the voter list and straightway proceeding to the election or verification process.
My lord, page 15, my paragraph 11, my.
Paragraph 11.
My lord.
Please read.
My lord, that it is respected someday, though on dated 28/11/2000, the present petition was present in the office and has also final application with prayer to allow.
No, we are not asking you that question. Where is your allegation that there has been a circulation of the voter list? There has been no circulation of voter list. Where is your allegation?
My lord, I have in the.
Your action appears to be post notification for verification.
My lord.
No,
yes,
that is not.
Yes, my lord. After that,
No,
my lord.
therefore first show you have an allegation.
My lord.
Don't
yes, my
argue. Don't argue.
No, my lord. I am not.
On illusion.
No, my lord.
Please come to your pleading. This is the stage requirement.
My
He
lord.
has to, on receipt of application, he is to display the voter list.
Yes, my lord.
And in order to receive objections,
Objection.
then follow-up action is also there.
My lord.
Therefore, you come and satisfy that there has been no compliance of this provision. Where have you pleaded that?
My lord, I have pleaded in my affidavit, my lord, regender affidavit.
No, sorry. Regender is no petition.
My lord, then, my lord, my next point.
No, you can't improve your case.
My next point is, my lord,
Yeah.
your lordship may kindly have a glance to my regender.
Are you sure what you are submitting, Mr. Tripathi, is according to the documents?
Yes, ma'am.
Take,
My lord,
page 12, the notification.
I only sought your lordship's permission, my lord, to have a glance to annexure 9, page 22.
You have missed the notification actually. You should have started annexure 12, annexure 3, page 12. Then in fact, you have responded to that.
Yes, ma'am.
So how do you say that it was not notified? Then what was notified?
No, my lord.
In that ODA annexure, you have responded that give me time.
Yes, my lord.
So what you simply answer, that no.
You did not object even.
My lord, we have asked for time due to the death of the mother of one of the executive, my lord. We cannot provide the documents, my lord. And your lordship came annexure 9, page 24. Only, my lord, your lordship
cannot be a ground. Once it is notified, that cannot be a ground that now that the death of mother of the legal advisor,
that is true,
it should be shifted.
My lord, that is true.
So you keep reserve all your submissions.
My lord,
your lordship
may kindly have a glance to annexure 9, page 24.
No, annexure 9 will not look.
No, your lordship may kindly. It is their letter. It is their letter I am relying upon. It is their letter. Kindly have a glance. If your lordship satisfied, then I have. After the publication, my lord.
Publication was date
7/12.
7/12.
My lord.
This is dated
12/12, my.
Yes. What they
My lord,
say?
after that, we have given all the documents and.
No, even assume there is a wrong communication. That should not have been a communication.
My lord, your lordship.
No, we will not go by that. It's a illegal communication.
No, it is not illegal communication.
Oh, you say it is not illegal. Show us the law. Show us the law that after the verification, notification is there, you will still have the opportunity of objection. Show us the law. No, once you say it is illegal, show us the law.
My humble submission in the counter.
Show us the law. Don't make any submission.
No, my lord. In the counter, he has not stated.
Forget that. Show us law. You said this is illegal. Show us law.
3A, my lord.
Yes.
3A.
No, 3A is prior action.
Yes, my lord. He has not circulated. He has not circulated the voter list.
Would you like to show us a judgment that yes, after the verification notice is already
yes, my lord. Yes.
You have objection. Show the judgment.
Yes, my lord.
Show the judgment.
Yes, my lord.
That still there is a scope.
Yes, my lord.
Yes, read that para. And you must be sure before placing
my lord
that was a case of consideration of objection after verification notice comes in.
Yes.
So with that background, otherwise we will throw this judgment.
My lord, it is
out of copy time.
Reference.
The other difficulty, Mr. Tripathi, what you are submitting is contrary to your pleadings and petition. It was duly notified. You responded to that.
Yes, responded.
But to start with, you have started arguing, it was never notified.
No, I am not said.
So please.
I have said, my lord.
Please mark the dates and sequence.
My lord, I have
think-
said
Are
that.
you having a date chat?
No, man.
That is the problem.
I have said that.
You miss certain dates.
No,
In fact, on your own, you have responded.
my lord, we have responded, my lord.
So
My humble submission.
why you are looking that side? Because you are in VC.
That's it.
Yes, come to your judgment. That judgment is not supporting you.
Yes, my lord. Yes.
As I was saying, this was a pre-11 stage. This is in 11 stage.
Next, my lord.
Huh?
My lord, it is the judgment I have shown, my lord.
Yes.
The petitioner came before the recognition, my lord. Your lordship, this honorable court disposed of the application.
Come to the pleading there.
My
Come
lord.
to the pleading there. Read. Pleading doesn't match your case.
Next, my lord.
Yes, after receipt of the writ petition.
Receipt of the order.
In the aforesaid terms. After said padantu. Third page probably. Second page.
My lord.
Second page padantu.
My lord, in such BU of matter, no exception can be taken to annexure.
Next para.
My lord, it disposed of in the aforesaid term.
That describes
After receipt of the order, my lord,
Hmm.
this court, the authority initiated the process for due compliance with the requirement of.
The authority initiated the process for due compliance with the requirement of sub-rule 3 of 11.
3.
So this is pre-notification stage.
No.
This is a case. No kahantuni, please.
My lord.
You have a
Sorry.
very bad habit of submitting. You have a very bad habit of submitting, saying everything no.
No, my lord, sorry, my lord. I may mission, my lord, sorry.
We are reading from the judgment, you submit no.
The judgment, my lord, once he has copied the petitioner.
Is it a pre-11 stage or not?
11.3, after 11.3, my lord.
Not even looking at the judgment,
Yes.
not looking at the pleading.
Your lordship, may I read, my lord? After receipt of the order.
That first line is itself clear. The authority initiated a 11.3 proceeding. So there arose a question of objection. Here it is notification already there for verification.
The objection was considered and rejected.
Okay, all right. Therefore,
My lord, may I read, my lord?
why? What you will read?
That from the judgment.
No, this judgment doesn't support you. We will not waste our time. We will not waste our time.
Your lordship, that is.
No, that judgment doesn't
That is
support
after
you. We'll
public-
give a finding, don't worry.
After publication of the voter list, the second writ was filed, my lord, in this case. After publication of the 11.3, procedure completed.
That might be court's indulgence is there. We don't
After
find any
considering,
indulgence
my
here.
lord, may,
Sorry.
may one, your lordship, may reject or allow, may, for my satisfaction.
Yes.
My lord, after considering the objection, the district labor officer cum returning officer Balasar opposite by order dated 15 April 2000 on annexed order dispose of the objection and convene a meeting for finalization of the code of conduct with regard to Silla. The representative of the most of the universe signed the minutes of 20th April 2000. On 21st April, by the annexed order, the returning officer opposite now in consent with the order dated 24th April 2000 of opposite number pass in exercise.
Mr. Counsel, you are not understanding. These are all pre-11 stage.
11 to after,
Yes.
my lord.
11 was active. Therefore, there was
No,
an opportunity available.
11 to completed, my lord. Your lordship, second, may I read, my lord? If I am wrong, may your lordship may dismiss my lord. On 21st April 2005, my lord, by letter dated the returning officer opposite party number in consent with the order dated 2005, the opposite party number pass in exercise power conferred under 11.2 rules notified that the voting by the secretariat for verification of the union functioning villa would be held on 18/5/2015. Being agreed, the petitioner once again approached the court alleging that the list of eligible voter has not been prepared or published in consonance with the law and such the election cannot be held.
Yes, that's all your submission.
My lord, after that, my lord.
Yes, what is your counter stand?
Lordship, they have been given sufficient opportunity to provide all the documents.
Read through counter. Read through your counter.
Lordship may come to page 3 of our counter, your lordship.
It is 1, 2, 3. Counter of OP number 1 to 3
My lordship,
is page 3.
page 3, your lordship.
Hmm.
That previously there was a opportunity that was given to them. They had sought for time. Again, your lordship may see, on considering the plea of the petitioner union, another letter has been issued by the deponent to the 3 defaulting unions, including the petitioner union, to submit required records, register documents for
No,
verification
please,
of member.
Please read from para 4. Please read from para 4.
The entirety, your lordship.
Yes, para 4.
My lordship. That as regards the averments made in para 5 of the writ petition, it is humbly submitted that the State Implementation and Evaluation Officer cum Labour Commissioner Odisha, vide his office letter, office order number so-and-so dated 2/11/2022, notified the deponent for conducting verification of the membership of trade unions functioning in Messrs. Grasim Industries Limited at District Ganjam for the purpose of recognition of trade unions under the rules 1994. Accordingly, all the trade unions, including the petitioner union, were requested by the deponent vide letter number 1326 dated 11/11/2022 to submit the required records register documents relating to the union on 16/11/2022 at 11:30 a.m. for verification of membership. However, the petitioner union, vide letter number 15/22 dated 16/11/2022, submitted an application for extension of time on the ground that their working president is suffering from ill health.
Yes. Then,
On considering the plea of the petitioner union, another letter has been issued by the deponent to the 3 defaulting unions, including the petitioner union, to submit required records, register, and documents for verification of membership on 25/11/2022 at 3 p.m. It is relevant to mention here that, except the petitioner union, all unions have submitted their records, registers, and documents relating to their unions on 25/11/2022 at 3 p.m. Thereafter, as per the provision under 11(3)(a) of the rules 1994, all unions were requested to attend the meeting on 28/11/2022 at 3:30
so these
p.m.
are all stages over.
Lordship,
These are all stages over.
my lordship.
Due opportunity was given. Had this.
My lord,
amendment.
my lord,
May
I may,
At the instance
your
of the-
lordship, paragraph 7 of that counter.
Yes.
Your lordship, my lord, kindly advance to last para. Last para, your lordship, may kindly advance.
Just 1 minute. Yes, Mr. Senapati, what is your
Yes,
submission?
I saw some.
Who are you? Who are you?
I am for the another union because of the stay order. The result has been
Okay,
not
right.
been published. That
Madam-
I have been included as party as OP number 5.
Huh?
I have been added as OP number 5. my lord.
OP5, right?
Your lordship may kindly say my counter. My counter, I have filed the sequence of the documents I have filed also. Where the petitioner.
Mark the running page 54, because you are not, no, none of you are referring to running page 54.
54,
Yes.
yes.
That the union participated in the election and pursuant to the impugned notice submitted his symbol. In my counter page 21, your lordship may see. In my counter page 21, pursuant to
Mr.
the.
Senapati, that point is well taken, but Mr. Tripathi is in a different league altogether.
That is,
So he's saying that he is now raising membership, the 15 number of membership issue.
There has
that
been
union. has
illegal-
not
So
said.
that my lord has been asking
There
that
has
whether
been
that is the
illegal
stage.
deletion of members.
No,
that is
no,
his-
reason. They are not the members of that union.
No, that's a different issue.
That is,
That's a different issue.
my lord.
He has to put up such an application or objection in due time. That stage is over. He was given time. He did not cooperate. Then the authority proceeded for final publication. Then the verification has come. Therefore, if he has missed the bus for
No.
him,
My
the
lord,
verification.
One development is
My lord,
there.
paragraph 7.
They are members of any other union, those 15 persons
Those 15
have
persons,
been verified.
this is their document.
No, no.
They the union's document. I have filed on RTI.
Only I,
On RTI,
Lordship,
which I am
paragraph 7.
submitted before
Sir,
the election.
paragraph-
Sir, you were hard when they did not.
No,
Mr. Tripathi, kindly listen.
Wait for it.
They very patiently were keeping quiet and standing also.
My lord.
So kindly give also them a chance if he is referring to a document. So just
Yes,
give
You are
him a
you are
chance.
referring to page
Your lordship may annexer C/5, your lordship may see.
E/5,
C/5,
C/5.
C/5. Page 14 of that my counter, the internal. Therefore, verification of the documents, thereafter, the union.
1 minute, 1 minute, 1 minute, 1 minute. Let us get into that.
67.
14 codes. Yes.
Page 14.
Hmm.
Here, the returning officer on 1911 directed for all the unions, I am to say meeting of hearing on objections and suggestions of final voter list.
That
Will
is
be-
his annexer also.
Yes.
Case 12.
Your
If
Lord-
not, when he's asked to look at that, he's getting annoyed.
The-
So what can be done?
Thereafter, the union, next page, your Lordship, annexer E/5.
Yes.
The union itself submitted their resolution and their membership. Thereafter, the annexer E/5, they give us the symbol as cycle. Annexer E/5, page 21. The union, petitioner union,
And it's a E/5.
E/5, page 21. Jayashree Chemicals Employees Union.
Internal page 25.
21, Miller,
21.
page E/5, page 21. Your Lordship got it.
Yes.
That employees union, where the petitioner is here, participated in the election requesting for
ask
Jesus
for a symbol.
symbol.
Ask
Thereafter,
for a
the
symbol.
thereafter the dummy that voter list was published. Dummy voter list, next page,
Hmm.
with symbol cycle to them, workers union, then Shramik union. These are they have participated in the election, and the election is over as per the schedule. And because of the stay order, the result has not been published.
Okay.
My humble
all right.
submission,
Just
madam.
1 minute. Please.
To that,
Who are you? You are the secretary.
my lord,
Himself claimed him
Okay,
as secretary.
the secretary now. There might be inside right. Yes, what is
my
your
lord, to that effect, my lord, I am only relying the counter of the returning officer.
You first satisfy. Who
My
are
lord,
you?
my lord, I am the secretary of the,
Secretary.
my lord, secretary.
You are the general secretary.
Yes, ma'am.
Okay, come to page 74, your document. That page, internal page 21.
21 of my lord.
That internal page 21.
Of my counter.
My lord,
Their counter. Who
My-
is the general secretary?
he is ex.
Therefore, there is the intra-rivalry. You are superimposed here. You are superimposed here.
Yes, my lord.
Therefore, yes, all right.
My lord,
We
for
record that. We
To
record
that,
that.
to counter
We
that, my
record
lord.
that. Please take your seat.
My lord, no, my lord.
Please take your seat.
My
No,
lord,
we will not allow.
That is not true, my lord. May I read, my lord, paragraph 7 of the counter of the returning officer.
All right, we'll deal with it.
In response to the letter,
We'll
only,
deal with it.
my
We'll
lord,
deal-
no, my lord, paragraph, I'm only, that para, I will finish my submission, my lord.
Yes.
My lord, your lordship,
That is
paragraph,
page 23. Since you are not getting the running page, that is page 23.
my lord, paragraph 7.
Karo affidavit, huh?
No, my lord,
Your-
counter of the returning officer,
Huh?
counter of the returning officer,
Counter of returning of
my lord.
page.
Page, internal page 5, my lord, 23.
State counter.
My lord, state,
State counter internal page 5.
my lord,
That is pleading.
my lord,
That is their pleading.
my lord, in
Yes.
response to the, your lordship,
Yes,
paragraph 7,
yes.
my lord, last para, my lord. In response to the letter, only Joyশ্রী Chemical Union submitted the relevant documents. The other three unions.
Yes, there are two unions, it appears. There are two unions, it appears. You are superimposing.
There are
Mr.
four
Tripathi,
unions.
that
Mr.
union.
Tripathi, regarding verification, there is no dispute that it was verified and it was ended, then election was held. Mr. Senapati's contention is very simple, that after the verification was over, for which you are very much dissatisfied, the election is over, and in election you have participated.
No, man.
So
We have not participated.
So he has shown the
My
sealed
lord-
election and your that representative
To counter,
to
my lord,
represent to
your lordship.
so
only
the
there are
counter refers to verification.
Not
Counter is not
verification.
referring to election.
no
That
nobody-
paragraph you are relying. So kindly read again.
Yes, in response to the
Nowhere,
letter, my lord,
Nowhere it deals with election part.
only Joyশ্রী Chemical Worker Union has
start-
submitted the
you
relevant
start-
documents.
You start kindly, so that is not talking about election. Just read the entire paragraph 7 from the beginning.
My lord.
Then you will realize it is discussion regarding the verification process, which Mr. Misra was referring to.
No, my lord, there are four unions. Three unions has not participated and has not submitted documents. And only one union submitted. My lord, only one union submitted the paper, man.
Sir, that is well taken. After verification, that notification, the publication of the list, which you are very much dissatisfied and annoyed or anxious, whatever terms you express, that you are challenging, the election process is over, that Mr. Senapati is contending, and obviously you have not denied that.
Election
You
is over.
when you are mixing up two things. You said that you have, in fact, you have shown that you could not participate in the process of verification despite given opportunities. One for mother's illness, the death of somebody, you went on that. So finally on 28/11, when the verification took place, you also did not participate. Thereafter, you filed a petition for the extension, but it was
Thereafter,
published.
7/11 after.
28/11, during the verification, you filed a petition for extension.
Right.
Check that.
Right,
That's
yes,
just what
no,
Mr. Mishra
yes.
was saying.
28/11.
Thereafter, the election was held.
Thereafter, 7/11.
And whoever was having cycle symbol, you are saying they are non-entity, but it is a matter of record. They participated. That Mr. Senapati is saying.
You are the non-entity. You are creating
yes.
problem there. Therefore, go and settle the score elsewhere. You are the valid union or they are the valid union. Go and settle the score elsewhere. This is no forum. I had the submission of Sri Tripathi, Learned Counsel, Sri Sonak Misra, Counsel for the contesting opposite parties, Sri Sangramji Senapati. You have still scope. You have still scope to rectify the issue. So you are not understanding what we are intending.
Yes, ma'am.
So you are running to the risk. We make it clear.
No, my lord, I have to approach the Labor Commission.
We don't know. We are not here to advise. You have given sufficient indication. We found the records. We found records that you are not the union. So you still run risk to getting a judgment.
No,
So what do you want?
I want to, my lord, approach the Labor Commission.
Withdraw this.
Just and last but not the least, see the judgment you are citing. Just mark the learned counsel who was appearing.
Yes,
You are trying to explain him the facts.
Yes, it is. It is.
Kindly mark the opposite party counsel who was appearing.
My lord is here.
So now you are also where he appeared, you are trying to explain my lord the facts, what happened.
So bisare konsi aur sandeha nahi. Because I have done so many cases.
My lord,
of this.
your lordship is
I have
appearing.
done so many cases. I was for all public sectors,
My lord.
government, central government,
I know
state
it.
government, public sector, I was there. Union matter ରେ ଆପଣ ଆସିବେ ମତେ କହିବେ
ଆଜ୍ଞା ମୋର ଏଟା ଫାଷ୍ଟ କେସ୍ ମାନେ
ଫାଷ୍ଟ କେସ୍ ହେଲେ ଆଗ ଲ ଟାକୁ ବୁଝିବାକୁ ହବ VMR rules is a very important rule କାହିଁକିନା ଆଗରୁ trade union election ଗୁଡାକ ବଡ ମେସି ଥିଲା so government brought a rule under the Trade Union Act to simplify the issue. Voter list ତିଆରି ହବ, voter list will be placed, draft voter list will be placed. Then the situation, unlike all other elections, there would a scope दिया हब, objection, correction हब, final list ଆସିବ, then a publication of the final voter list along with notification of verification. Then people participate, they select their leader. chronology ଟା ଆପଣ ଜାଣିବେ ନା ଆପଣ ଆଗକୁ କରୁଛନ୍ତି ମୂଳରୁ ଧରିଲୁଣି document your document shows like I had in the course of submission it appears through document page 74 of the brief that Joyশ্রী Chemicals Employees Union through its general secretary nine of 9368 not only participated in the verification process but has come to submit its request for allotment of election symbol. This court in reading of the document at page 29 of the 28 and 28 of the brief again finds the process of verification involved Joyশ্রী Chemical Workers Union find place at serial number 1 in the said notification. From page 74, it is again noticed General Secretary one Ranjit Kumar Padi, the Prusti, being the General Secretary of the recognized union, appeared, contested, submitted for election symbol, and as a consequence, running page 76 discloses there is allotment of the symbol being in favor of the recognized union as per his own request, its own request. And it is pursuant to its written request number 1425 dated 7/12/2022. Looking to the cause title here, this court find though the petitioner claimed to be Joyশ্রী Chemicals Employees Union, but represented by somebody else in the course of submission, there has been clear admission that there is dispute, intra-dispute involving such union. There is involvement of intra-union disputes, which issue cannot be a subject matter here. For this court finding, the recognized union, namely Joyশ্রী Chemicals Employees Union, having been allowed to participate, and for the further disclosure through the counter affidavit of the opposite party number 5, such union even has also participated in the election process. This court here find even though election is already concluded, there has been no declaration of outcome for interim order intervening there. This court find doubt in the petitioner status involved in and observes there is serious doubt in the local standard of the petitioner in involving in the verification issues unless it resolves its dispute through the appropriate mechanism and gets a favorable order in its favor. In the process, this court find the repetition at the instance of petitioner is not entertainable. At this stage, thus while dismissing the writ application, this court records the further request of Sri Tripathi that it may be permitted to bring the intra-union rival issues before appropriate authority. And this requisition stand disposed. Petitioner to work out its remedy as per its counsel's advice.
Interim or interim. Be vacated, result be published.
Yes.
Interim order be vacated and result be
Interim order
published.
stand vacated. Free copy of order be handed over to Sri Sonok Mishra.
Your Lordship, here the one thing, Your Lordship dictated Ranjit Kumar Pushti, that is Pradhan.
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 Okay, Pradhan. Audio sir.
It is there.
All right. All right, ହଉଛି ଶୁଣନ୍ତୁ ୟୁନିୟନ ରେ ଏଇ ସବୁ ଜିନିଷ ହୁଏ somebody comes କଣ ହଉଛି ସେତିକି ବେଳେ କୋର୍ଟ ର ନଥାଏ ସ୍କୋପ ଜାଣିବା ପାଇଁ ଏଇଟା ଆକ୍ଚୁଆଲି ଯଦି ଲେବର ଲ କରିଥିବେ ନା ସେଠି ପଚାରିଦେବେ ଆପଣଙ୍କ ରେଜିଷ୍ଟ୍ରେସନ ସାର୍ଟିଫିକେଟ ଟା ଦେଖାନ୍ତୁ
ନାଇଁ ତାଙ୍କ ପାଖରେ ଅଛି
ସେଇଠି ଧରିଦେଲେ ତ ସରିଯିବ ଖେଳ ସେଇଠି
all original documents with that
ମ୍ୟାଟର
all original documents with that
ହଉଛି ହବ ଆଉ କଣ
ଆପଣ
କରିବା
ଟିକେ ସାଇକେଲ ଟା ବି ଦେଖନ୍ତୁ ତ ସରିଲାଣି କେସ୍ ସାଇକେଲ ରେ ଦେଖନ୍ତୁ ସେ ରେଜିଷ୍ଟ୍ରେସନ ନମ୍ବର ଯୋଉଟା ସାର୍ କହିଲେ ଲେଖା ହେଇଛି
ସବୁ
there is a complete trail of that union through the entire process.
Maybe
But you are not satisfied that somebody has been deleted. That is another issue altogether. But ସେଇଟା ଆଣିକି ଏଠି election stay କରିବାର scope. Anyway,
next matter.
Okay.
Item 10.
Item 10 Lord, may be permitted on similar. Here, Your Lordship, the order of the Lord GRF is under challenge, and the main ground is meter tampering. Lord, Your Lordship, may I take
Meter
a Lordship?
tampering. One minute, yes.
My Lord, sorry.
This matter was entertained by order of this court dated 13/1/23, thereby directing notice on the contesting opposite parties. From the office note, this court find there has been already service of notice on the contesting OP number 2. Despite service of notice, nobody is appearing to give a contest on behalf of OP number 2. Therefore, this court is constrained to decide the matter ex parte.
in absence of OP.
Absence of OP number 2. Right. Yes, Argo, you are the powers of, you are the licensee.
My Lord.
Okay.
Your Lordship will, may I take a Lordship to the relevant page 15, annexure 2.
No, what are you challenging? What are you challenging? Annexure of the order of the grievance.
Annexure,
GRF.
order of the GRF.
So what is the direction of the GRF?
GRF direction is, it's a case of raise 126 proceeding unauthorized use of meter tampering, and provisional bill was issued, provisional order was passed, and the consumer did not appear. He approached directly to the consumer approached directly to the GRF, who has no authority, but because it's an order passed under section 126 of the Electricity Act, because of the meter tampering.
From the first page of that page 11. So which column is relevant? You are
Page
saying that it
11
is not entertainable by GRF.
Yes, it's not entertainable by GRF because it is 126 proceeding. That is a provision of provision 126. There is a appeal provision. 120.
It's a meter tampering issue.
Yes, my Lord. Clear part of
consequential billing.
My Lord.
Consequential billing. Let us see what are the jurisdiction.
My Lord.
GRF notification to the
Your Lordship, Electricity Act, my Lord. Section 126.
Notification ta dona compare xerox copy The Regulatory Commission. Ombudsman ଟା ଏଥିରେ ଆସିଲା କଣ ବିଷୟ ଯିବ Forum for Redressal of Grievance. Forum appointment of Ombudsman as a secret. Functions ଅଛି ଏଇଥିରେ ଆସିଲା. Yes, read. If you have a book, it says the OERC Grievance Redressal Forum and Ombudsman Regulation 2004. Forum city ଲେଖା ହେଇଛି subject to the provisions of Electricity Act, rules, regulation, notification made thereunder. Forums generally dispose of the complaints relating to defects, deficiencies in electrical service as defined in the relevant regulation. For example, the nature of complaints are illustrated below. କାଇଁ ପଢୁନାହାନ୍ତି? ନାଇଁ ଆପଣ ଭିସିରେ appear କରିବେ ଆପଣ ପାଖରେ relevant କାଗଜ ରହିବନି ଏଠି pondering around କରିବୁ କାଗଜ କଣ help କରିବ ପାର୍ଟିଙ୍କୁ?
Sorry, my lord, I was relying on the 126 Act section 126. I will refer, my lord.
That everybody knows.
My lord.
But GRF has a specific jurisdiction or not?
My lord, GRF has a jurisdiction.
So that is a relevancy or not?
But where there is a specific, yes, your lordship, jurisdiction is there. But my respectful submission before lordship is when a proceeding is drawn under section 126 and there is an appeal provision and he has not appeared before the he has a if he has a genuine grievance, my lord, he could have appeared there, my lord. He has accepted the notice. Only 2 months penalty has been 2 months unauthorized use here, not even 1 year. And the clear cut meter caught and meter body was caught, and the GRF has taken a different view, granting 30%. That is also not there in any. And the entire
don't dilute your submission.
My lord, no.
You stay confined to the jurisdictional aspect. If you shift from the jurisdictional aspect, then you are accepting this jurisdiction.
No, my lord. Your lordship may see page 12, internal page, last
so
paragraph.
Therefore, come to. Mr. SAHOO, na?
My lord.
Mr. SAHOO.
My lord.
Mr. SAHOO.
My lord.
This is a bill, penal bill under 126 or not?
Yes, my lord.
So come to clause 5 of the GRF jurisdiction.
ଆପଣ ବିଲ୍ ଟା ଏନକ୍ଲୋଜ କରିଛନ୍ତି କି ଫେର ତାକୁ ଖୋଜିବା ପାଇଁ ଫେର ଆଉ ଥରେ
ନାହିଁ କିଛି କରିନଥିବେ କାମ ସବୁ କେସରେ ମଧ୍ୟ
I will file, my lord. I will file, my lord.
You will file.
Sorry, my lord.
ତାହେଲେ ଆଜି ଯୋଉ ଆମେ ସମୟ ତକ ନଷ୍ଟ କଲୁଣି କାହା ପାଇଁ କଲୁ?
ସେ ପାର୍ଟଟା ମୁଁ ସାର୍ ଜାଣିନଥିଲି your lordship referring jurisdiction. But here I was preparing in another.
Dismiss, there is no foundation to satisfy.
Your lordship,
and 126 is well covered in the jurisdiction. It says billing disputes except penal bill under section 126. So therefore, if it is a penal bill, then it outs the jurisdiction of the authority. You don't argue that.
Yes.
So therefore, bill can only satisfy whether it is a penal
here not bill, my lord. Here the penal bill for 2 months, my lord. Because
penal bill for 2 months. What do you demonstrate? Demonstrate that.
Your lordship may see the page 15 is the report, my lord. Your lordship kindly, I was referring. You kindly see, my lord. Page 15 of annexure 2, page 15, my lord. That is the cause of action, my lord.
At the time of inspection, we found
may I read, my lord?
that meter dispute was
meter display was showing earth symbol meter display is showing 1.16 ampere, where Sony tester is showing 4.4 ampere.
To bring the bill at least to establish that it is a penal bill.
GRF रे दिया ହେଇଛି ଆଉ ଏଟା
GRF refer करछि कि कोठी
my lord
GRF कोठी refer करछि कि
GRF accepted that it's a penal bill but proceeded that
कोठी refer करछन्ती GRF जे एटा penal bill बोली
आगे करछन Lordship, may I see para 2 our stand there, para 2 of the respondent number 2 page 12 Miller. Paragraph 2 Miller. The respondent in the counter reply that Chandra so plot number has been availing power supply on thin kilo domestic and paying his electricity rent on so due to defect of meter, a new meter was replaced on 9/12/2020.
Just 1 minute.
Sorry.
That's so complaint nije कहूची grievance stated it verified his meter and broke complain otherwise you have broken the meter seal.
The meter seal has to be broken, Millard. Once the verification that is not disputed.
Then have you taken the signature of the consumer before?
Yes. Consumer signature is there.
Where are those materials?
Where
are those materials?
My lord, page 15, Millard, signature is there. That is the
page 15. It is the only
after breaking the meter.
So verification.
So that we have marked.
My lord.
Please read these complaint first 4 lines. It is vividly, he says vividly that what has happened.
That ground they can say, Millard, that is
it's not a question of ground, it's a matter of giving a petition before a GRF who has jurisdiction. He goes to the GRF, says that they came,
I admit, Millard,
broke my meter, prepare a report, I am illiterate and asked me to sign, I signed it.
May I clarify?
My lord asked you that, did you take a consent from him to break the meter? You say yes, he has signed.
Millard, once the routine verification
you might have done that, but it is not part of the record here or before the GRF.
That is the procedure, Millard, verification, presence, signature. May I point out one thing, Millard?
See. No consumer understand what is the verification process.
My lord.
You go, you threaten for disconnection, then he is under compulsion signing.
May I point out what the GRF has done? May I point the crux of the matter is page 13 in Lordship may see. GRF has said that clause 117 of OERC regulation 2019 says in case
Mr. SAHOO, actually, please read the first paragraph. What you are missing, you will realize.
My lord. I understand, Millard. Your lordship is referring that.
Sir, I have not said anything. Upon the Trikadarsi ite buji parte. Mu to kichi kahi na upon kon buji parte. Subsequently, the respondent has forwarded him a provisional assessment and final assessment. That is not part of the record here. Kindly read that. What the GRF was dealing with.
GRF has said
just the first paragraph, last 4 lines. Subsequently, the respondent has forwarded to him a provisional assessment and final assessment, which the complainant is not able to pay, and has requested to his forum, for getting the relief and issue necessary orders to avoid such harassment by the respondent.
Then your lordship,
apart from filing here or enclosing here this verification report, neither you have enclosed what was the provisional assessment. No,
Millard. I may that last paragraph your lordship refer that order that clarifies the position. Provisional assessment was issued before final assessment. He approached the GRF. That is the finding. That page, very page.
Where is that, sir? Where is that provisional assessment?
Page 12, sir. Observation.
The provisional assessment. So let us see that. Page 12 is the verification report.
Then page 12 order
we are not that ignorant, sir. We are not that ignorant. That a verification report you will submit that it is a assessment.
Assessment at the stage of provisional.
Or Mr. SAHOO, if you are serious, then we have to record that.
Your Lordship,
That page 12 is the provisional assessment.
I am bringing it to Lordship's notice. It is in the stage of provisional assessment. The consumer
Sir, we have already noticed. If you are serious, then we have to record that page 12 is the provisional assessment. Then you have to face the whatever will follow.
I'll file that. Provisional assessment already filed it before the GRF. I'll file it.
Now come to the order part. How do you agree? Suppose there is a disputed fact. You say the meter has been tampered. He says you have broken the seal. Therefore, neither GRF nor we can in a position to go into such aspects. Now what the GRF says? GRF says in this situation, let him pay 30% of the final assessment, and you put a new meter, get into the average. So what is the harm?
My lord, yes, your lordship. My respectful submission to your lordship's.
You are not prejudiced, Mr. Sahu. Why are you arguing?
I understand. My lord. Here, the only difficulty is the GRF has applied clause 1 on regulation 117 of OAFC code.
Forget that. Come to the final part of order. He is not following anything there. That is discussion process. Come to order portion, page 13. What is the direction ultimately?
Direction is to pay 30% of the assessment.
So, no, not only 30%.
Revision, yes, I'm coming.
Direction is to collect 30%, put a new meter, take the meter reading, find average, submit a final bill, he will deposit. So, how are you prejudiced?
Period revise all the average bill.
Yes, absolutely.
Clarification
because he has recorded the complaint of the petitioner.
Yes, he has recorded.
Rather.
Yes, it has been recorded.
So
but only difficulty is enter average.
So there is allegations and cross allegations. You say
that allegation the lordship knows
when that is consent neithile ki before breaking the seal, because that's the normal rule. Apna nahi nahanti consent break kar dele. Why did you break the seal?
Break by separate consent, that is no problem.
So therefore, we don't find you are prejudiced by this
Once verification is made in presence, signature is taken only. That is the practice. The signature is taken and in place.
So we don't find you are prejudiced. Sorry.
Your lordship says I am only on the ground of jurisdiction.
No, jurisdiction you have shifted. So once you have argued on the merit.
The jurisdiction is not.
Don't have now.
We have also taken in GRF, Millard. GRF
don't have now.
Before your lordship, I have said GRF also.
You may be claiming it's a meter tampering case, but the GRF has disbelieved that.
GRF
has disbelieved that. Therefore, it is coming under this clause 5.
But even if accepted, Millard, your lordship's view, Millard.
So therefore, don't have now.
Application of regulation 117 is not there. My respectful
had the submission of Sisa Mahanti, Mrs. SAHOO, then at council appearing for the petitioner. This court, by order number so-and-so, has recorded open number 2 not showing interest in contesting the matter. The matter is decided only hearing the counsel for the licensing. The writ petition involves a challenge to the order of the GRF, grievance redressal forum Bhubaneswar, in short hearing after GRF, appearing at Anesoban. Background appearing, the case appears to be. Background in the case appears to be the consumer being the complainant complains the GRF, specifically alleging on 18/2/21 at 2 p.m. EPCODL verified his meter and broke his meter seal for checking of status of the meter. On their submitting a physical verification report, petitioner signed. The same was signed by both the parties. Complainant alleges he signed the copy in poor understanding or without understanding of the report. But however, with a bona fide impression that he will be getting a justice by the staff. On submission of a final bill following such development, the petitioner requests provisional and final bill. Petitioner requests the GRA for appropriate relief. Licensee the respondent to, in their appearance, alleged during routine visit to the above premises, involved on 18/2/21, they found that the consumer has avoided power supply through tampered meter, that is cutting the backside of meter body and obstructing the actual metering. This court records here the submission of Sri SAHOO that there has been no obtaining of the undertaking of the consumer before breaking the seal of the meter. It is in the above context of the matter, the GRF has raised a serious doubt in the claim of the licensee. However, to find an appropriate resolve of on the resolve of the issue involved, finally passed the order by Dhanesha 1, directing the complainant to pay 30% of the final assessment bill amount raised by the respondent, the licensee herein, and thereby also allowed the respondent, the licensee herein, to install a digital meter in place of old meter, having provisions of recording demands for assessment of actual connected load. And in the process, the GRF also authorized the licensee to raise the further bill for payment by the consumer involved herein, dependent on the average bill to be raised by the licensee. Being agreed, the writ application has been brought, being agreed by such order. In his contest, Sri SAHOO Learned Counsel taking to the pleadings in the writ application and on reiteration of their stand in the GRF, firstly contends the GRF has no jurisdiction to entertain the issue involving penal bills, for there is specific provision through Section 126 of the Electricity Act 2003. Party has a recourse by way of remedy elsewhere. Secondly, above argument of the counsel for the licensee appears to be, even assuming the GRF has jurisdiction, there has been no proper consideration of the allegation aspect by the licensee. In the above scenario, Sri SAHOO claims interfering in the order at Dhanesha 1 and setting aside the same. It is unfortunate to note, even though licensee challenged the impugned order Dhanesha 1 passed by the GRA, there is, however, no filing of the provisional bill, nor the final bill, nor even the complaint or the response of the licensee filed before the GRF. However, on reading of the recording of stand of parties by the GRF appearing at page 12 of the brief, this court finds the complainant has a clear allegation of breaking of meter and seal in the meter by the departmental people. And there is also a complaint with poor understanding on the indications in the report he has signed. This court here find the GRF has recorded the complaint of the response of the licensee that there was appearance of tampering of meter. As a consequence, a report was prepared for the petitioner, for the consumer sign such report is restored from taking such step. If GRF appears to have taken a decision on such plea, finding doubt in the finding it to be a question of fact. Right. And has come to observe after hearing the parties and going through the documents, the respondent's team leader, enforcement cell, verified the complainant's premises on 18/2/21 and found that the connected load has been enhanced from 3 kilowatt to 16 kilowatt, with meter being found tampering. But the meter was installed on 9/12/20. Hardly 2 months before this, or 2 months, that is 2 months before the verification. The DRF also came to record taking cue from the provisions at section 126 of the Act and clause 117 of OERC Regulation 2019. Providing in case of installation of meter with provision of recording demand for the consumers with contract demand less than 110 kVA, the highest record demand during the billing shall be utilized for billing and charges. This court here takes into account the provision at clause 117 of the OERC Regulation 219, which reads as follows. This court here find in first attending to the question of jurisdiction with the GRF being raised by licensee, the GRF has taken the claim of the parties remaining in dispute for their contradictory statement for the claim put up by both the parties. There is no clear material establishing that there was consent of party taken before opening of seal. Okay, so there is apparent lapses on the part of the electricity department. In order, the bill can be taken to be a provisional bill and final assessment. In this circumstance, this court find there is no dispute with there is no problem in the GRF in undertaking such exercise. Further, looking to the provision taken care of at clause 117 of the OERC Regulation 2019, and further reading here the direction part this court find the direction not only taken support of the clause 117 of OERC regulation 2019, but there is even no prejudice to the licensee here, as it is in the first hand getting 30% of the final assessment, and in the second stage on installation of a new meter, there can be a final assessment on the basis of average consumption. Which is certainly appropriate in terms of the clause 117 of the regulation 2019. In this circumstance, this court find there is no infirmity in the order requiring to interfere in such orders. If the order of the GRF by Danish 1 is not worked out, the license is directed to the what is the position? Has he deposited 30%?
That instruction.
Huh? Has he deposited this 30%?
That instruction is not.
You can't have. You should have that instruction.
In all likelihood, Mr. Sahu, you would have installed the meter now, because you could not have carried out with a defective meter, because your stand is
How the power supply is continuing.
so you are giving. So
meter,
in fact, you have implemented the order. That is how he is not appearing.
Yes, the council has no information as to the reason of reconnection, because a party cannot stay without power for such long period. Counsel for the prisoner has even no instruction on the deposit of 30% being directed by the GRF involved herein. Okay. In the event there has been restoration of the power, there is continuing of the power supply, the decision of the parties involved herein are directed to comply their part. If not complied as of now, within a period of 10 days, and on compliance of the GRF direction, if there has been no final settlement of the bill in the meantime, let there be final assessment undertaking average exercise as directed by the GRF, at least within a period of 3 months, 2 months or about. No response on the continuity of power supply. And as this court observed, no party can run without power supply for such long period. In the event there is already installation of a new meter, it may be open to the licensee, if necessary, to raise a final bill on on the basis on average on average taking average of the first 6 months bill okay, see 117. Final bill may be raised in terms of regulation 117 of the regulation 2019. Read with 126. Read with 120 under section 126 of 2000. 100 to read with 126, section 126 of the Electricity Act, 2003. Hala? This observation, the revision stand disclose, a quotation of
Publish.
judgment kar do. Dismissed, but however with the aforesaid observation. Instruction ଶୁଣନ୍ତୁ ଆପଣ argue କଲା ବେଳକୁ the power supply councils all appearing. Please take update instruction in such matters. Can there be a consumer continuing without power for 2 years? So you must have settled the issue in the meantime.
And can they supply continue with a defective meter?
Yes. And even otherwise also, one cannot continue with a defective meter. सीधा बस जाउछन्ती आर्गुमेंट करूछन्ती आमे ताले सुनନ୍ତୁ एणिकी जदी एई बडी इश्यू आसीबो डिसमिस कर दो नो इंस्ट्रक्शन रे व्हाई शुड ही लेबर
Item 11.
11 Miller.
My lord,
Eleven-
I'm appearing on behalf of opposite party number 2 and on behalf of
बिजनेस में की है
My lord, I am appearing. my lord.
हां yes what is this case
The
कौन
sta-
कौन कहउछन्ती you are ready
yes, my lord. I'm appearing on on behalf of Mr. Seshadev Das.
for the consumer
Aye.
एथिरे इंस्ट्रक्शन अछि ना नहीं अपडेट
No, instruction.
यदि
It is
नहीं
similar
नीड
case.
करंतु
I will take instruction.
कौन डायरेक्शन कौन हेतला ये भी सही 30
Similar direction.
सेम मैटर तो
Lordship.
Similar direction. Yes.
हां एथिरे कॉन्टेस्ट रहउछि सेम ऑर्डर होबो यस लिखा आपनकर पोजीशन कोन पावर सप्लाई
My lord, I do not have, but power supply has been given. New meter has been installed.
new meter has been installed
Lordship. But after installing, they took 10,000 rupees for me, and before that, they took 40,000. So total lordship, they have taken 50,000 rupees for me.
Okay.
From the final assessment of rupees 1 lakh.
you go on paying the current bills
Lordship.
current bills
Lordship.
50,000 is one third Miller.
देखो
30%.
पार्टी आसीची से
My
कहउछि
lord.
आपण नुवा मीटर लगै छलनि माने you have already implemented the order
My lord,
I से हमको लेबर भीतर को नउचंदी
I'm sorry, Miller.
please don't argue on evasive
Miller, I have no
This
instruction.
court
Otherwise, I
records,
cannot.
records. Similar matter has been decided in the disposal of WPC number so and so. Hala. In this case, there is of course appearance of the consumer, the OP number 2 by counsel, who volunteers to submit that after the GRF order, there has been not only installation of a new meter, there has been also payment of the amount involved in the bills as and when revised, raised. Well, this court for the installation of new meter, observe the rest part of the direction of the GRF, if not complied, may be worked out accordingly. आज्ञा से काम सरीबनी आपनको
आज्ञा, आज्ञा।
परमिशन दउ नहीं आपण अननेसेसरी आगु करछुंदी बतन बिल कले से कहबे हमें केबुल गुडा वर्कआउट कर देइछु
आज्ञा। Obligation.
देखो आपनको पेमेंट से दउछुंदी कि नहीं इफ नॉट वर्कड आउट करबा the direction full direction of the sorry whole direction of the GRF if not worked out be worked out within 2 months का
sorry
40,000 नहीं है 30% ଟା ତାଙ୍କର 30,000 ହେଇଥିବ
40,000
ରେ କିଏ ଅଛନ୍ତି
obliged lordship
For hearing item,
12 ରେ କଣ ଆସିଲା କିଛି
Lordship,
କିଛି
we're
ଖବର
supposed,
ଆସିଲା
yes, the instruction we have
death
already,
certificate you have to produce
death certificate we are yet to get, your Lordship, but your Lordship directed me to file an affidavit on the last
at
occasion.
least हाँ
We'll file it by today, your Lordship.
ଆଜି ଫାଇଲ କରିବି ଠିକ ଅଛି ଏଟା ରହୁ ଲିଷ୍ଟ ରେ ହେଲା ଲିଷ୍ଟ ରେ ରହୁ ଗୋଟେ ପାର୍ଟହାର୍ଡ ମ୍ୟାଟର ଥିଲା କୁଆଡେ ଗଲେ नो नो मिस्टर मिश्र was arguing आपन मैटर टा पार्टहार्ड थिला
Lordship.
your matter was already
Yes, yes, my
parted
lord. My lord. That
and
is
the
part.
written note of submission anichindi
My lord, earlier occasion I have filed one written note of argument, my lord.
aji
but-
karibe ki
That may be ignored, my lord. I am filing a fresh written note of argument.
you will file
My lord, just
काली
now,
काली देखिबा टाइम जदी बंचियो काली आपन मैटर तो आगे सारीबा
lordship.
अदर कॉपी दाउ दे दियंतु स्टेट को
Lordship, the previous written note of argument may be ignored.
ignored
my lord.
all right she Mishra learned counsel appearing for the petition eta hochi eta hala 17 hala 17 submits claims for ignorance of the previous written note of submission and in the course of today in court files a fresh written note of submission along with written note of submission along with citations which may be kept on record. There is already service of copy of written note of argument on the
My lord.
prosecution counsel. Mr. Nandi, are you ready? Place the matter. It a list rahibo to be
My lord, tomorrow.
list of citation देई नांती खाली खाली list of argument देई चलती
My lord.
खाली list of argument written note of submission
Written note of argument only.
खाली written note of submission
My lord, because
Mr.
there
Nandi
was-
ready
ready generally I am not doing this general
no
matter.
no variti
ଆପଣ
ସେଥିରେ କଣ
ଦେଇଛନ୍ତି
ସନ୍ଦେହ
ଗୋଟେ-
ଅଛି ଆପଣ କରୁନାହାନ୍ତି ବୋଲି କରିପାରିବେନି
ନାଇଁ ମୁଁ ନେଇ ଟିକେ ତାକୁ ଆଉ ଲିଷ୍ଟ ରୁ ଆଉ ଟିକେ
ଲିଷ୍ଟ ରେ ରହୁ ଆଉ ପାଇଯିବେ ଆଉ 24 ଘଣ୍ଟା ପାଇ ଯାଉଛନ୍ତି
ଟିକେ ଲାଷ୍ଟ ୱିକ୍
ଦେଖିବା।
ଅଫ ମେ 15 or
ଦେଖିବା
16
କାଲି ଯଦି ଏଇଟା ହବ ଆପଣ କେସ୍ ଟେକ୍ ଅଫ୍ ହବନି ଆମେ ଏଇଟାକୁ ଆଗ ସାରିବୁ
ହଁ ମୁଁ ନେଇ ନାହିଁ ବି ଇଏଟା ପେପର ବୁକ୍ ବି ନେଇ ନାହିଁ ନେଇଯିବି
ପେପର ବୁକ୍ ନେଇନାହାନ୍ତି
ନା
କାହିଁ
ନାଇଁ ଟିକେ ଏପଟ ସେପଟ
ନେଇଯାଆନ୍ତୁ ନେଇଯାଆନ୍ତୁ ଆପଣଙ୍କୁ ଆସି କରାହେଲା ଆମେ କିଏ ସ୍କୋରି କରାହେଲା ଆଉ ନ ନେଇକି କାହିଁ ଅଛନ୍ତି ତାଙ୍କୁ ପେପର ବୁକ୍ ଆଣି ଧରେଇ ଦିଅ ରେଷ୍ଟ ଅଫ ଦି ମ୍ୟାଟର ଲିଷ୍ଟରେ ରହିବ ହେଲା This council doesn't want to press the matter. Dismiss as withdrawn. File a memo. File a memo.
Yes.
Hmm?
Item number 2.
Item 1, my lord. Petitioner challenging Annex 11, my lord. It is a cover matter.
Subuni kichi.
Petitioner challenging Annex 11. It is a cover matter, my
No, no, item 2 is a review.
lord. One, my lord.
It's a review case.
No, my lord. Item 1.
ना कौन टा withdraw कर लगे item 1 ने mention कर दी गले पर हाँ
30.
item 13 wait when the matter reaches दाले कोटे slip दे दी जान तो हाँ Yes, item 1 कौन covered what is this what is the issue involved
My lord, challenging the
okay please be on mic सुनो दी
challenging the lease case, my lord. Challenging the order of assistant settlement officer Bhunsor, my lord, arising out of a lease case number 2028 by 1979, cancelling the allotment of a leasehold lease beyond the statutory
no, this
period.
matter notice has been issued already or this has not been admitted at all.
No, my lord.
This has not been admitted as of now. Why should it be entertained now?
Covered matter, my lord, already decided by the division bench.
Decided, then you take advantage of that order, withdraw this.
I am filed separate, my lord.
Then why did you not bring this matter there? No, this is not a case to be taken covered by this judgment. Sorry, come to page 98. Come to page 98.
My lord.
First of all, you are challenging Annexure 11 or Annexure 1?
Annexure 11.
You are challenging Annexure?
Page 98.
Annexure 11. Yes, page 98. Where is the certified copy of the order? So there is no filing of certified copy even of the impugned order. Matter was filed in 2017.
Let it come next week, I will file.
Huh?
Let it come next week.
Auri debi kona de au aniba 10 ବର୍ଷ ପରେ aniba. Now see the order.
Copy भी देना
Copy read भी नहीं. Read the order.
with defect ଅଛି stamp report.
Read the order. प्रलम्ब अशुद्धि भितर अच्छी मकदमा कॉपी दे नांती सर्टिफाइड कॉपी ऑफ इम्प्यूग्ड ऑर्डर फाइल हेनी 17 मसियारू एपर्यंत एडमिट हेई नहीं
I have fresh appear in this case.
हां काई नउतले केस काई नउतले पढ़न पेज 98 पढ़ले कौन लिखा है Where is the scope for interfering in event? Badapetre padon subi vajenti.
Case record is put up today. On verification of record, it is seen that the suit plot number 8076 by 8308 corresponding to Sabik plot number 2727 and Sabik khata number 205 of record stand recorded in favor of government in Onnavadi khata. During the last operation, since the petitioner has not submitted
relevant document in support of law in the title from government khata, the claim of the petitioner rejected. You did not have any document to support you. So withdraw this. If you have a document, go again. What is there to be decided here? At the submission of land counsel for the petitioner. Writ petition involved challenge to order at annexure 11. Considering the submission and on perusal of the grounds of rejection, this court find there has been rejection of the objection case 10036 of 13. In absence of any document to support the case of the petitioner being produced before the competent authority, there appears there is technical rejection of the objection case. This court find no ground to interfere in such orders. Dismiss the writ petition accordingly. Petitioner, if he has any other remedy, dismissal of the writ petition may not stand on his way to undertake such remedy. Yes.
Item number 2.
Yes, item 2, anybody? Item 2, anybody for petitioner? Nobody is pressing these applications. Dismiss. Counsel for opposite party is present in court.
Item number 3.
May I please, Your Lordship? Your Lordship, in the present contempt petition, the contemners have willfully violated the order dated 21/9.
Is it first contempt?
Indeed, Your Lordship.
First contempt, normally I grant some time. Okay. 1 month time for me.
Obliged, Your Lordship.
Is union paying Mr. Paddy and
Mr. Gochayat.
Gochayat? Mr.
Copy
Gochayat.
maybe I don't have a copy.
As a matter of last chance. 1 month as a matter of last chance.
A copy maybe, sir, madam. We don't have a copy, that's why.
Copy de diyan.
Yes, Your Lordship.
Yes, next. Contempt or copy de diyan.
In the course of day, Your Lordship.
Item
Yes.
4.
Item 4, my lord, today I am filing counter, my lord. I will serve copy, my lord.
Okay, yes. Let us defer it for some time. Counter is being filed today in court with service of copy on Sri Mishra, counsel appearing for the petitioner. Sri Mishra, learned counsel, seeks some time to take instruction on the counter. Vacation पर आसु.
As your lordship pleases.
Vacation पर. First week after vacation. Second week after vacation. Yes.
Item 5.
Item 5.
Item 5, my lord, I have received instruction, but I am not satisfied. That's why I am further direct for further instruction, my lord.
Last order, your lordship may kindly see, he was to. The state council undertook that the defect by the collector should be rectified.
Yes,
by
yes. That's why I ask for further
He is to
instruction.
recall that.
केबे आनिबा गोटे सप्ताह पर आनिबा
ए छुट्टी पर
छुट्टी पर देखिबा he may come to your rescue.
ना मु कहि ऑलरेडी सेटा लास्ट टाइम
आरो वीक रे आसु इंस्ट्रक्शन पाई जाई जोन
नहीं आरो वीक रे से आनिथिबे न आनिथिबे 17 तारिख रे आसु
आगे
17 तारिख रे आसु.
Yes.
Keeping in view the request of state council who is in process of reconciling the issue.
Item 6.
Item 6, my lord, I will prefer appeal. Lordship permit me.
You will prefer appeal?
Yes, ma'am.
Further is statutory remedy of appeal. Sri Lenka, learned counsel appearing for the petitioner, seeks withdrawal of the writ application. Withdrawn, however, with liberty.
Item 7.
Mutation revision case is pending before the district magistrate.
Pardon?
Mutation revision case, annexure 1 is pending before the district magistrate collector Kandama, Gajapati matter.
Wow. Settlement of property.
Oh, yes, my lord, that is a civil court decree in favor of the petitioner.
Yes.
In view of the civil court decree, the mutation appeal has been dismissed. So that a revision case is pending before the collector district magistrate.
You will bring a revision.
Yes, my lord.
So you want to withdraw?
No, my lord, that revision case to be decided by the listed in my state.
Where is the revision number?
That is annexure 1 at revision bracket OMM case number 2 of total.
Considering innocuous prayer involved herein, this court in the disposal of the writ application direct OP number 3 to give a lawful disposal to the revision OMM case number 2 of 2021 pending before it by working it out at least within a period of 3 months of the date of communication of order.
OP number 2 my lord.
OP 3 will prayer election. Collector ta OP kete?
2.
OP 2?
Yes, my lord, that is my.
Prayer correction karantu.
Well, let me.
OP 2 karja. Upar likhido oral on oral submission, learned counsel for the petitioner is permitted to make necessary correction in prayer in court.
There is a miscase, my lord, interim status quo in respect of the record, my lord.
Status quo. Sorry. Yes, next. Pardon the more judgment heichi vitere. Setre mo koichi joti interim order nahi provision nahi. Seti what will be the consequence of the order impugned therein? So judgment padiki take help of that judgment.
That is any OD Act by
ODA re karchi, but I have given reference of so many acts there. Therefore, wherever there is no provision, it will be applicable. Yes, next.
Item 8.
My lord, in this matter, I had filed a caveat, my lord.
All right.
Copy I have served on my lord.
Just
served. Copy I have just now served on.
Copy aji debe.
Served, just already served.
Already served.
Just now, sir.
Just now. Tale pardina asu.
Monday asu. Monday asu.
Monday.
Pardina asu, my lord, because there is a direction to evict me from my land.
Pardon?
There is a Tahsildar has directed that I should vacate my, they should dismantle my fence, my lord. And there is a direction to the RI to initiate proceeding under section 8(1).
Where is that direction?
Next, sir, your lordship have a glance at page 17, my lord.
17?
My lord. Paragraph 6, my lord, they have communicated the order to the standing council, and in that order they have said that
this is a proceeding under what provision of law?
Nothing is mentioned, my lord. There is a PIL was filed.
One PIL was filed by the
And what contents?
villagers, my lord.
That is pursuant to direction of this honorable court.
Yes, my lord.
In WPC number 35967.
Direction was to consider the repentation. Now my fence is.
Let us see what is the direction. Where is the direction?
Direction to consider our representation, my lord.
Direction ta dekhiba. Please give copy of direction in 35967 of 22.
I was not a part of that copy I have obtained.
It is on eviction issue.
My lord, the present petitioner stating that I am a landless person, taken the government land 32 decimal and encroached 42 decimal. And villagers are filed a PIL. Before that also filed a writ petition. They filed a PIL to encroach to disencroach that.
All right.
Yes,
It is an outcome of the PIL order.
Yes, my lord.
So are you involved here?
Nothing, my lord. Your lordship, previous paragraph of that impugned order, page 17, your lordship have a glance. Paragraph, next previous paragraph, paragraph 5, that after hearing both the parties and verification of the documents submitted by both the party, it is found that the suit land has been settled in the name of OP number 5, by the OP level case number so and so, bearing so on. So this land is settled in my favor, and there is already a measurement was made, and the government land was.
You are a party there.
I was party, no notice was served on me, and
Yes, party there, and so
PIL representation was disposed of at the stage of admission, and I was asked to produce whatever document that there in my favor, and I produced that this is my document, my pata, everything is there. Now thereafter, under what on what document the Lording Tahsildar has come to the conclusion that my fence, that is my residential house is there.
No, what you submit on the allegation that you are to be entitled with 42 or 40?
30, government land 32 decimal taken. लीज तांको नारे हेची से 42 डिसमिल को एनक्रोच करछन रास्ता दो
आर 10 डेसिमल छाड़ दो ना कहीं
नाही किछि नाही मेजरमेंट हे कि गवर्नमेंट रास्ता ये लॉट्स में हैव
I want to say one thing, my lord. माने जड़ जमीन देइछंती तापर से घर कर देइछंती. That is also clearly described in the order, my lord.
who are you madam
आमे सब विलेजर्स माने करिथिलु रिप्रेजेंटेशन जड़ जमीन ताको निया कि तापर से कर देबाटु घर आमे बिल के चाष करि पारनो जाई पारनो.
at the same time there should not be any dispute on 32 decimal.
Yes, ma'am.
32 upar there should not be any
have a glance at that photograph I am submitting.
32
that land as they initially disputed that there is I have enclosed the road. Measurement was made and the road was carved out. Now concrete road is adjacent me. Now the allegation is that my fence is causing inconvenience to the adjacent boundary.
That's right. सुनो तो आपन को जदी 32 decimal दिया हला
सेटा जड़ जमीन
you should remain in possession of 32
I
decimal.
have 32. Yeah, I have no claim over more than that area, my lord. I have not encroached anything.
If you have not encroached, then why you have been asked to vacate?
जड़ घर कर देइछंती पाचेरी कर देइछंती.
Lekha is due to fencing by the OP number 5, the boundary tenants of surrounding plots are facing a lot of problems.
There is no such finding, man. On what basis?
No, there is a finding, no such finding.
My lord, on what?
Para 6 product.
That is the observation of the Tahsildar, my lord. But if any inquiry is conducted by the RI or something, is that copy? You lords may have a glance at the photograph. Adjacent road is the concrete road is there. There is no possible at all that my boundary.
Then why have you not put up your case there?
Well, I was just asked to whatever document available with me in support of my claim, I produced it. And they have found it in paragraph 5, they have recorded that it is then stands settled in my favor.
No, they say 32. Therefore,
32,
there is
by
also
beyond,
no dispute
beyond
by
32,
them.
your lordship direct, let them carve out my land 32 decimal if anything I have.
Okay, then yes, all right. You will be squeezed down to 32 decimal.
My lord.
Balance land will be vacated.
My lord,
32 डिसमिल जड़ जमी पई दिया है स्पेशल एग्रीमेंट इज देयर ताकू से घर कर की
तळ पई देइचंदी से ताकू स्थळ रे व्यवहार कले कि कोन कले दैट्स अ डिफरेंट इशू your dispute is he is occupying beyond 32 which is creating your problem. So ताको ओटा मेजरमेंट पे डायरेक्शन दे दिछि तांकर जो 32 डेसिमल देइछि सेटा कार्व आउट हे जाऊ माप हे जिवो से तांको फेंसिंग सेठी की शिफ्ट कर देबे.
If I have at all
against this order, we had already filed a appeal.
कोटा against this order.
हां
कोन पे अपील करचंदी?
जे हमें एक्चुअली दीटा फ्रेयर नै कि हाई कोर्ट रे करथिलु जे सीए तारो लैंडलेस पर्सन
जदी अपील पेंडिंग अछि अपील पेंडिंग अछि तले स्टेटस को मेंटेन हो से अपील रे जा आउटकम हबो.
अपील नंबर ता मते आसीनी मो नंबर ता देबी आसी कि मंडे
I record you have filed an appeal. Therefore, since an appeal has been brought, you may also go and appeal.
appeal is there.
appeal रे से माने appeal फाइल करछन ना से तो स्टे में आनिबेनी से तो वेकेशन पे ही चीज काय appeal लाइछन भगवान जानती.
नहीं लैंड
In the course of submission it has been brought to the notice by Ms. Manasi Mahapatra Learned Counsel appearing for caveators that against the impugned order herein there has been already filing of appeal pending before
sub collector, my lord. I am not confirmed, but
before the appellate authority. Before the appellate competent authority. Hala. Keeping in view there is already appeal undertaken involving the impugned order, this court permit the parties to fight out their litigation in the appellate authority. Plus, for there is appeal provision there. It may be also open to the petitioner to prefer appeal, if any, along with interim application to protect his interest. So far, it relates to 32 decimal. As per the observation as per the recording of the competent authority in impugned order, para 5. Till the outcome in the appeal, there should be status quo in respect of 32 decimals.
Yes, sir. Road ta se jemti encroach karibeni.
32 decimals ko hi rahibo hala. 32 decimals on plot number It also para 5 okay.
455/99.
Okay, this court records the submission of learned counsel for prisoner that in the event there is any encroachment beyond 32 decimal, he will clear that based on a demarcation process undertaken by the Tahsildar. ହେଲା ତହସିଲଦାର କେ ଭିତରେ କହିବେ ଏଟା ହାଇକୋର୍ଟ କହିଛନ୍ତି ଡିମାର୍କେସନ କରିଦିଅ ମୋ ଜାଗା ଦେଖେଇ ଦିଅ ସେ କଣ ହେଇଥିବ କି ଆପଣଙ୍କର 32 ଟା ପଛକୁ ଥିବ ଆପଣ ଆଗକୁ ଆସିକି
ଆସିକି ପୁରା ରାସ୍ତାଟାକୁ ମାଡି ଦେଇଛନ୍ତି ଘର ବି କରିଦେଇଛନ୍ତି ପାଚେରୀ ବି କରିଦେଇଛନ୍ତି ଏବେ ତ ତହସିଲଦାର ତାଙ୍କୁ କହିଥିଲେ ଯେ ଏଗ୍ରିକଲଚର ଲେଟର କନଭର୍ଟ କରିଦେବା ପାଇଁ
any request is made to the concerned Tahsildar for demarcation, the Tahsildar shall entertain the demarcation application and undertake the demarcation exercise, but in the involvement of the parties in appeal, the cavator herein and or the parties in appeal. Well, ଆପଣଙ୍କୁ involve କରି measurement হবে.
Let them serve a notice or call.
No, ସେ ଦବ ତହସିଲଦାର ଦବ କରିଦେଇଛି in the involvement of the party likely to be affected. Okay.
Copy of the order.
Free copy of order be handed over to State Council. Next is 9.
Item 9. Item 9.
Okay, even though nobody appears, this quote from the player and the pending representation at page 21 finds on the self-same issue there is already a raising of objection before the opposite party number 3. In the event, the body of page 21 also discloses there has been receipt of such complaint, page 21 and 22 by competent authority. 21, 22, 23, so 24 years. For the pendency of a request before the competent authority, the writ petition stand disposed, directing opposite party number 3 to bring out a lawful disposal to the complaint of the petitioner in the involvement of party likely to be affected by working it out within at least 3 months' time. Yes.
Item 10.
Item 10, Your Lordship, I am challenging the order of sub-collector by annexure 5, whereby they have observed opposite party number 6 as the son of the petitioner, Your Lordship. Your Lordship, in the similar matter, notice has been issued also, Your Lordship.
And then,
Your Lordship.
no, but the appeal appears to have been disposed of with a remand order.
Your Lordship, but issue is that they are taking observation of that sub-collector, Your Lordship.
Observation may not be prevailing.
Your Lordship, they are taking.
So you place your case in the remand proceeding. Where is the observation? Let us see.
Observation, annexure 5, page 24.
Yes.
Paragraph.
Which para?
Fourth para, fifth line.
Yes, the pura parata padon.
Shri Purti R.I. Hare Krishnapur has wrongly reported in genealogy of deceased RTE recorded tenant Madhav Pradhan that Madhav Pradhan has successor wife, one son and married daughter, whereas he has 2 sons, namely Swaraj Pradhan and Gangadhar Pradhan.
Okay. Let him not be swayed by this observation. Independent decision because this is a disputed question. He may be agreed by this.
And he has filed a civil suit, that same person in annexure 6, whereby he is claiming to be son of someone else. Annexure 6, page 26, Your Lordship.
So you place your case before the additional Tahsildar, he will not be influenced by this observation.
Your Lordship.
Had this submission of council, State Council. Petitioner sole grievance involving an appellate order passed in mutation exercise to the observation of the appellate authority in para 4, sub-para 4, page 24 of the brief. This court find in the allowing of the miscellaneous appeal mutation appeal, the appellate authority has remanded the matter for redisposal of the mutation case 200/15. For there is open remand to the Tahsildar involved herein. This court find there should not be the Tahsildar should not be influenced by observation in para 4 herein above, and to take a decision independent of his own, dependent on the case placed by the parties therein. Allow with this observation, the proceedings stand disposed.
Deeply obliged.
Yes.
Item 11.
That the petitioner has purchased the land in the year 83, my lord. Applied for settlement before the settlement authority, and was asked by the annexure 4 page 14. He was asked to submit the documents. The Mauja Sampur, my lord. Still it is opening. So
You have a mutation case pending.
my lord, mutation case. No, settlement. I have.
Okay, sorry, correction of record.
My lord. So since it is open, I only pray, let me allow to submit the documents.
So notice involved what proceeding? Annexure 4 notice?
Annexure 4 notice was issued by that time. I also submitted the documents.
He has filed the documents in the objection case, my lord. He has filed the documents in the objection case.
Okay. Objection case is over or pending?
Not pending.
That is pending, your lord.
So therefore raise your objection in the objection case.
That's
what the read court will do.
Only
prayer,
only to allow me to submit, and he'll take a step in
Okay, if
accordance
you
with
have
law.
any objection, go there and.
He has already filed the documents before the ASO.
But your prayer is issuing necessary ROR.
That is not for me.
That is my.
In the modification of prayer, learned counsel appearing for the petitioner submits, he should at least be permitted to raise his objection in the objection case pending by Annexure 4. Considering innocuous prayer, this court observed in the event the petitioner has any interest in the objection case, a land involving the objection case, it may be open to the petitioner to bring his objection in the proceeding by Annexure 4 for consideration of the competent authority, at least by filing such objection within 10 days hence. This order will be worked out, however, subject to pendency of such proceeding, pendency of the proceeding by Annexure 4. A proceeding जदि pending थिबो ताल जे हबो इटा उटे 29/4/13
से जहा कहउतले
जदि pending नाही ताले आपण फाइंड आउट करिवे कोन आपण पे अदर ऑप्शन अवेलेबल
12 is also same.
11, 12 same.
12 is also same.
12 also same. कुआडु ए पुराना महिला कागज आनि कोडा आसिले आपण 13 मसियार नोटिस सब फाइल करछन्दी ये भी 13
आया
provided such proceeding is pending. Yes. Free copy of order to State Council. Yes.
Item 13.
May I please, my lord?
Yes.
My lord, here it was a similar matter. Yesterday, 2 matters were there. Their mutation appeal was been allowed in favor of the present petitioner, and the learned sub-collector has directed the Tahsildar to inquire about the matter. The matter was been remanded back to the Tahsildar, but he was till that he has not acted upon.
Your lordship.
ये जो माने record दउ नांदी
आगे नहीं आगे
record दउ नांदी
ना
काली थिला ना
last lordship में kindly
काली गोटे matter थिला बरा
आगे item 20 and 21
कालर 20
Your lordship may see the prayer.
it will be transmitted immediately.
Your lordship may see the prayer, my lord. He has
That was the
prayed,
representation.
The Tahsildar is to determine the genuineness of the sale deed. He is to cancel the sale deed.
Son, remand the he said.
Yes, your lord.
But prayer.
Remand ele se tankar objection ja debe
But the prayer cannot be.
petition proceeding is reopened.
Yes, yes.
Into not being taken up for the non-receipt of the records.
Yes, your lordship.
A prayer time ti kahi
Prayer portion
आगे जेतु representation गोटे देई
prayer ta को gondoliya करछन ना तेनु she is justified in raising an objection. Kalra se matter रे ja order देई in modification, in partial modification of the prayer learned counsel at least 6 early remittance of the LCR involving mutation case number so and so, following the order of the appellate authority in MA number so and so. Fit in
In item 20 and 21.
15 also, 14, 15
also.
14, 15 same.
14.
How kete case achi imtia?
ଆଉ ଦୁଇଟି ଅଛି ଆଜ୍ଞା।
How achi?
ଦୁଇଟି।
Huh?
ଆଉ ଦୁଇଟି ଅଛି।
Doti.
ଆଜ୍ଞା।
Yes, rest of the cases after recess kariba.
Obliged.
May I please, Your Lordship. My lord, here the petitioner applied for certified copy of a mutation case, my lord. Till now it is not available. He has also deposited the fee, my lord, by the annexure 2, page 8.
Now this is pending copy application.
Yes, my lord. Certified
Yes, sir.
copy of the mutation case, my lord.
He has applied for the entire.
He applied on 27/6/2020.
He has applied for the entire order sheet. Your
Yes.
lordship may grant
Then
some days time.
supply
Yes.
whatever fees is required, you
Yes.
will notify and supply. Why it is taking so much
He has
time?
already deposited the amount, your lordship.
Huh?
He has already deposited the amount
And
required.
then why it is pending so long?
Your lordship may direct to supply the copies.
At the submission of the council, it's an unfortunate case. The petitioner herein is approaching for a writ of mandamus in the matter of supply of certified copy, dependent on the copy application by the annexure 2. This court recording its anxiety in such disputes, unnecessarily wasting time of the High Court. However, direct the
Tahsildar Barang.
OP number
3, my lord.
OP number 3 to forthwith act on the copy application of the petitioner. If in the event any further deposit is necessary, there should be immediate notification on the same. Copy involved be supplied at least within 10 days of the
My lord,
production of order.
Item 20 and 21, similar.
ସବୁ same.
10 days from the date of receipt of the copy of your lordship.
20 and 21.
No, 19 and
Sorry,
20.
19 and 20.
No, sorry.
Okay.
Obliged.
Your lordship may say from the date of production of the certified copy by your lordship.
Madam, ये फाइल केबे हितला जानिछंदी? ये रीट पिटिशन के फाइल है 25 रे.
Oh, yes.
आज हमें कितने तारीख हेलनी?
3 तारीख.
You should have taken steps on your own. You are new counsel here, therefore I am not opening my mouth. So therefore, realize that's a copy application pending since June.
Yes, yes. That should have been supplied by.
Is it not surprising? And why should a person come to High Court for writ of mandamus?
Your lordship.
So behind you go on arguing from the date of supply.
But they should
Sate
know.
jemti se America ru jinso aniki dobo.
They should know the order of your
Sorry.
lordship.
You should have advised. Have you at all communicated the authority? 25 ru file. Have you at all communicated the authority? Argument sake argument kale hobo. Sobu VC chalani. Please be careful hereafter.
Deep look.
Item 17.
You are not doing your duty. Mu 6 मास ହେଲା ଗାउची जे आगे गोटे ओपन करंतु सेक्शन टे ओपन करंतु आपनकर रीट पिटिशन टे देला पर इमीडिएटली कंसर्न्ड अथॉरिटी को आस्क करा जो कोन व्हाट इज द इंस्ट्रक्शन.
In this matter, the petitioner seeks seek a direction to dispose of the mutation cases pending before
You
the
seek disposal of the mutation case pending.
my lord.
And for that, a 80-page read
The
petition.
private opposite party raised an objection, my lord, against the order of the civil court appeal is pending. That's why the mutation case is not disposed of.
That is your instruction.
No, that is the amendment made in the writ application. Para 4. First appeal is pending against the civil court decree.
Appeal is pending.
Lordship.
Appeal means civil appeal.
Yes.
Where is that amendment?
Para 4, your lordship.
And your lordship may kindly see the unnecessary.
Just 1 minute, 1 minute, just 1 minute. He is raising some objection, let us see.
The defendant number 19 and 20, my lord, they preferred appeal.
Okay, then what is the bar? Where is the bar in giving a record of right subject to outcome in civil proceeding?
No, there is no bar, my lord. If the record of right is corrected, they can be utilized for the fiscal
You being
purpose.
Tahsildar, why are you worried for all these things?
That can be used for the fiscal
You provide
purpose.
it, you provide. Suppose there is already, here there is already a decree prevailing.
And the appeal is pending.
Appeal is pending.
Yes.
Has the decree been taken away?
No, your lordship.
So, what is your worry?
No, there is no bar to mutate
So,
the land, my lord.
give it without prejudice.
Yes, without prejudice, but
Yes,
because of the
why
fiscal.
should you take a order on that? Why your Tahsildars
Lord,
are not
they are
working
saying
on that?
Since the appeal is pending before the court. your lordship.
Maybe. Appeal is a dispute between parties, not with Tahsildar.
Yes. But they are afraid of, my lord, since the case is
No,
pending, my lord.
No, you just go on raising objections. Sorry, yes, is there any stay of the decree
No,
passed
no,
in
my
civil
lord.
court?
My lord,
Then why are you raising objection?
No, I am not raising objection, lordship. As per para 4, my lord, he has stated the appeal is
He
pending.
has stated, no
Yes,
doubt.
yes.
Then you advise your client.
Yes, sir.
In the event there is no stay of the judgment decree,
Yes,
then
there is
he
no
should
stay
be
of the
giving
appeals.
the ROR without prejudice.
Yes, lordship.
Writ petition simply involves direction for disposal of the mutation case mentioned in the prior portion, case session. In the course of submission, Miss Mishra, learned counsel, you are AGA,
No, yes.
AC, learned AC appearing for the state. Through paragraph 4 submits, there might be some impediment in view of the pendency of appeal involving judgment and decree in CS 79 of 2014. There is clear submission in the bar. There is no stay of civil court judgment in the pending appeal. In such event, this court find there should not be any bar in preparation of in disposal of the mutation case in terms of the civil court judgment and decree. Preparation of record of rights depending, in this situation may, however, without prejudice to the rights and contentions pending in appeal. So, keeping this in view, this court in disposal of the writ application direct the Tahsildar.
Sukinda, open number 2.
Open number
2.
2. Dispose of give a lawful disposal to the miscases number so and so, so and so, so and so, so and so, however, dependent on the civil court judgment and decree presently. And a record of right is prepared. May also indicate the grant of such record of right shall be without prejudice to the parties, claim of the parties in the pending appeal. Entire working may be done within a period 2 months from the date of communication of order, but however, in the involvement of parties likely to be affected. Yes.
Oblate.
Item 18.
Yes.
May I please, your lordship. My lord, here in the Eastern case, my lord, the petitioner has challenged the illegal selection of appointment number 3, my lord.
Subuni.
Selection of appointment number 3, my lord, for opening of a petrol pump, my lord.
Okay. This matter was there day before yesterday.
Yes,
Matter
my
was there day before
Yes, my
yesterday,
lord.
it was directed to be listed along with the other pending matter.
Yes, my lord. Yes, my lord.
So what is the other matter?
Other matter, my lord, I'm not supposed to file the counter within 3 days. I'll file my counter, my lord.
You have not filed. What is the issue there?
Already issue is he has offered land. A portion of land belongs to his mother, and a portion of land is offered without any document. And subsequently, he has offered
To participate in the selection process.
no, he was selected, and field verification was made. In the field verification, it was found that the land dimensions was not meeting by the land offered by him. And
So his participation was rejected.
no,
Participation was rejected. By
participate
Annex 5.
land offer was rejected, my lord.
Okay, that was not suitable.
No, my lord.
So that is the dispute pending there. What is the present dispute?
Present is already OP number 4 has been selected, my lord.
Has been selected. So what is the purpose of bringing a new writ petition? What is the purpose of bringing a new writ petition?
Earlier
This
restriction, my lord.
This
Your
is
lordship-
an outcome in the same proceeding.
Yes, my lord.
So bring amendment.
During your lordship has put a question on that day, last occasion, yesterday. So you have to withdraw this earlier writ application and withdraw this. I am permitted to withdraw. I have already filed an memo.
Which writ petition? Eta withdraw kari paribeni karantu ni agya. Then that cause of action will go away. You did not make the case clear.
Yes.
Therefore, on the other hand, they should withdraw this one and place amendment there.
Yes, my lord. And in that writ application, my lord, I have filed 4 miscases. IS.
Copy not served, my lord. None of the
copy already.
That miscases, those miscases are not taken up now.
I could have been more active.
It's your choice.
Had my friend.
All right, take notice here.
No, my lord. I may not misunderstood.
The question of admission, any action involving the impugned order shall remain subject to result of the writ petition. Place this matter along with the requisites as undertaken by day after tomorrow. Place this matter along with WPC 13929 of 22.
Oh, bless.
There.
Let him serve a copy on that earlier second writ. The new rate copy has to serve. I have not received.
So have you filed your power here?
No, my lord. Or let notice go.
All right. Since Sri Srinivas Patnaik has already appeared for the oil company. Okay. Notice by your service of copy on Sri Patnaik be made by day after tomorrow. Union India pe bhi copy de do apne kohe wala. Yes. All right.
Oh, bless.
1920 for
1920 surgery, 21.
I count 21.
21 made, please, your lordship. My lord, this is regarding mutation of a land which was bought in 1954 by a unregistered sale deed, my lord.
Sorry.
Your lordship, may kindly see annexure 2. This was the revision petition preferred for registration of the for recording of the name.
7-1 proceeding.
Yes, my lord. Yes, my lord.
Yes.
And after that, if your lordship could see last part of the order.
Page 14.
Page 14, yes, my lord.
14 report in view of the aforesaid discussion.
In view of the aforesaid discussion, this court reached at this conclusion that the sale of immovable property worth of value less than 100 rupees is not compulsorily registrable, and there was no restriction on transfer of land by an occupancy tenant, whether or not he belonged to a scheduled tribe during the period of sale. In this context, it is to be considered as to how far the petitioner is entitled for recording a name by virtue of the unregistered sale deed as per the provisions contained in section 54 of the TPI 1882. Then there was a direction in the above scenario, keeping in view the observations indicated above, the concerned Tahsildar is directed to take action after due inquiry of position.
Right.
And
What happened?
Then your lordship may see page 16, my lord.
Yes.
This was in 3/1/2014, my lord.
What is the observation?
Observation is registered as
suo
suo
motu
motu
mutation
mutation case, send the CR
That
to
is
ACAT
still
for
pending.
Yes, my lord. This is still pending, my lord. 2021 is the report of the RI, my lord, at page 17.
regarding the possession.
Yes,
my
sir.
lord.
Give a lawful disposal to such.
Yes, my lord. I only pray, my lord, that there may be a recording to the effect that this judgment, in view of this judgment of this honorable court, my lord, regarding a similar matter, this may be taken into consider while taking a decision.
Your lordship may see the prayer portion.
So already you place reliance of this judgment there.
My lord, only your lordship may observe one
I
line.
had the submission of Sri Das, learned counsel for the petitioner, and Miss Misra, learned AC for the state. Petition involved the following prayer. Sri Das, in the course of submission, taking this court to the direction part of the competent authority involving a section 37 bracket 1 of the OCH and PFL Act proceeding, brought to the notice of the court that there has been already disposal of such proceeding, but however with a direction to the Tahsildar concerned for taking appropriate action after involving an inquiry. Taking this court to the development through Annexure 3, it is brought to the notice of the court that after entering into inquiry and even in spite of receipt of a report of the revenue inspector, page 17, so motor proceeding mutation case, even though initiated, but there is no conclusion of such proceeding. Considering there is sufficient delay in the disposal of the proceeding by order dated 3/1/14, page 16, to avoid further loss in the disposal of the writ application, this court directed the Tahsildar Latikota to give a lawful disposal to the so motor mutation case involved herein, at least completing the same within a period of 2 months from the date of communication involving party likely to be affected, taking into consideration the report of the revenue inspector by page 17, as well as copy of a judgment, copy of order of this court dated 9/9/21 in WPC 17138 of 2020. In the event, certified copy of such order is produced before the Tahsildar concerned.
Item 22.
Similar, my lord.
Same,
my
lord. Same order, same annexures.
Yes, my lord, same annexure.
Page also same.
Yes, my lord.
देखिए वाला.
Item 23. 23, your lordship, second contempt.
23 first contempt.
My lord.
23, is it a first contempt?
No, second contempt.
Second contempt.
My lord.
What was the direction in the read?
That is, your lordship.
Justice Mahapatra order.
Page 7, your lordship. The directed to dispose
Read
of with the direction that in the event
read para 4 and 5.
My lord.
Read para 4 and 5.
Taking into consideration the submission made by learned counsel of the party, this writ petition is disposed of with a direction that in the event the petitioner file an application for mutation in proper format, enclosing
So you have filed in proper
yes,
format?
Yes, your lordship.
Since
That
when?
is page 11, your lordship.
All right, give a conclusion.
Lordship.
At the submission of respective counsel.
It's a second contempt, though, your lordship.
Second contempt.
My lordship. Your lordship had already directed on 24/9/2020.
Yes, despite that, there is no disposal. If there is a contempt order, you are unable to dispose. Mr. Misra, why don't you bring this case for extension?
Lordship.
It's not proper in bringing a second contempt even.
Lordship.
In the first round of litigation, WPC 19911 of 2021 was disposed of, thereby permitting the petitioner to bring appropriate application in the matter of mutation. Through page 11 herein, it has been established there has been bringing in of appropriate application. Not only that, the proceeding in the meantime has also been registered as mutation case 2021. It is brought to the notice through page 16. Even after a contempt disposal since 24/9/2022, there has been no showing of outcome in the mutation case pending. Taking serious cognizance on the lapse of the contemner herein, however, to find a lawful resolution to the proceeding pending, this court permit the contemner to show a lawful disposal to the mutation case number so and so by concluding the same at least within a period of 1.5 months. However, providing opportunity to the party likely to be affected, if necessary, in the involvement of special messenger of cost from the petitioner, with communication of outcome to the petitioner within the 1 week thereafter. Failure of compliance of this court will not hesitate in initiating a suo motu contempt against the contemner.
Item 24. 24, my lord. Direction was given, not complied the order of this noble court.
First contempt. First contempt.
First contempt, lordship, the last order, my lord, directed to take instruction.
There was a direction here.
My lord. So whatever it is the case of the allegation that is
So what was the direction? Already complaint pending before the
No,
collector
the
of the
interdepartmental inquiry has already been started and the hearing date has been fixed, your lordship. We have received the instruction.
Date
Lordship,
already
grant us some
fixed.
more time.
When we have not received any, well, lordship, the impugned order is 20, page 20, my lord. Will it
All a departmental proceeding, if already initiated, then what is the?
One departmental proceeding, my lord, it is a case. The Sarpanch has.
Can that be decided in a contempt?
No. The no departmental.
Contempt is non-compliance of order.
That's true.
What was the order of this court?
No, I think, my lord, the wrong instruction is wrong, my
Please
lord.
be on mic. Please be on mic.
My lord.
Be on mic.
My lord.
हाँ ठीक है माइक आगे रहंतु हाँ पुणी पळौचंदी आपण सियाडू आउटी आडू सुनंती हाँ नै माइक धरंतुनी आपण सुनंतु आपण जेतले आर्गु करूचंती फुटे घुंची जाउचंती माइक रहि गला सेठी आपण आ फुटे आडे छिडाउ नांती घुंचले माइक आगे रहिबे हाँ because voice is to come through that only. Yes, let us come to know what is the read court direction.
Read court direction, page 20, my lord. Page 20.
Yes, considering this limited request.
My lord, because it is a case, the Sarpanch having 2 children who was elected, that is the allegation is defeated Sarpanch. And this honorable directed
Required to be adjudicated in exercise of power under section 26.
20 of GPR.
So a proceeding initiate helani.
Proceeding has been initiated. Notices has also been issued, your lordship.
All right.
We are only granting
Then
30 days more
take
time.
some time.
No,
My lord.
so my lord, I till date I have not received any notice. Let us say when the notice was issued. I have not received.
I'm giving them a copy.
Give the notice.
At the submission of Sri Mahanti and Sri Sonok Misra for the respective parties.
My lord, may I please, lordship, kindly, my lord. This shows that notice has been issued on 3/6.
पुणी माइक आगु पळौचंदी मु सुनिबी कोन.
Notice has been issued, it shows that it has been issued on 3/6. My lord, on today, my lord, the collector has issued, and when the order already, direction is already.
Can this be considered in a contempt?
My lord,
A Gram Panchayat Act 26 proceeding has been initiated. So contempt court will take cognizance. Kai sarunanti 5 din re, 15 din re. What are you placing?
I am placing, my lord. They have
Please
violated
withdraw.
the
Otherwise, I'll dismiss.
They have violated the order.
No
my lord.
contempt will be there.
Lordship, the hearing has been fixed to 6/5,
Sorry,
my lords.
no contempt will lie in these proceedings. It's a proceeding to be initiated. It has to be lawfully disposed of. You have been noticed or not, he is making a communication. Go and appear there, volunteer to appear.
No, since I have not received, I have not appeared. So my respective submission will
The requisition was disposed
disposed
with the following order.
Proceeding may be
Keeping in
disposed.
view the direction in the writ application, this could find for the direction in the event a proceeding under section 26 of the GP Act is initiated, there should be lawful disposal of the same. Filing instruction memos remisser brought to the notice of the court that in the meantime, there has been already institution of a proceeding under section 26 of the Act, OGP Act. And simultaneously, notice has also been issued. The communication further disclosed. The matter has been posted to 6/5/23 at 11:30. Copy of this instruction has been served with the contempt applicant. Petitioner, if so advised, may appear on the date fixed and place his case. With this observation, the contempt proceedings stand dropped. Yes.
Item 25.
Is it
Instruction
backend
memo-
violation,
instruction
not
memo so
non-compliance?
filed.
Lordship will
We kept
remember
that record.
that
Yes,
the petitioner filed one writ application first when his big shopping complex was being constructed in front of his house.
Mr.
Your
Krishna,
Lordship,
what is the order involved?
My lord, order involved is page 11. But then again, when that order was communicated to them, they issued this order, annexure 5. This order, Lordship, can to page 11, interim order.
Yes, read para 3.
Para 3,
or is it involving an interim direction?
Interim direction.
Okay.
As an interim measure, it is directed there shall be stay of notice under annexure 5 till next date of listing. My lord, kindly see annexure 5, annexure 3 to this page 14. But annexure 5 is the notice to demolish.
Yes.
Notice to demolish and
What happened? They have demolished or what?
No, not they have demolished what they have passed order, Lordship. How they have treated your Lordship's order, kindly see.
Okay.
Page 14, my lord, 1-4.
Page 14.
See, contempt of page 14.
Yes.
Second paragraph. It reveals that Honorable Court is pleased to grant interim protection against the notice. Therefore, the notice issued for demolition and assessment of fine is stayed till next date of listing of the matter. However, it reveals Honorable Court has not granted any protection against sealing of the premise.
Hence, you are had the submission of the Mishra and senior counsel, assisted by Sri Senapati. Mere perusal of the development through annexure 3, it clears there is serious deliberate violation of the order of this court. Dated 11/4/23 passed in IA 5175 involving WPC numbers and so. This court is inclined to issue notice of contempt. Requisites as undertaken be filed by day after tomorrow. Place the matter. Okay. Objection, if any, be filed within 2 weeks of the service of notice. Yes. It's a municipality or NAC. So who will take care? Let them appear there.
Yes, my lord. In that writ application I filed that to remove that sealing. Then remove that sealing. I have filed an IA in writ petition. Writ petition attached to it.
What have you filed?
The seal, but to remove the sealing. They have sealed it.
In the read you have filed. In the read you have filed.
Writ petition filed. You also have filed.
Read a notice is subsequent ହେଇଛି କି?
Notice subsequent ସେଇଟା
they are not appealing.
ପାଇଛନ୍ତି ବା order ଟା ଲେଖୁଛନ୍ତି ଏଇ order ଟା ପାଇଛନ୍ତି ବୋଲି.
What happened to notice? Let us see. No, if I give their direction, then the contempt will become infructuous.
Okay.
Therefore, let them do whatever they want to do. On the next date, we'll see.
Fixing date.
Place the matter. Pendency of the writ application is a contempt. Pendency of the contempt shall not stand as a bar even in recalling of the order involved herein. Hello. Place the contempt application on 27th of June.
27th of June.
27th of June. Yes, I made an observation. If the good sense prevail, let them, they may recall that order.
Let us hope for the best, but I don't think so.
No, state eitile I could have prevailed upon them.
State
Persuade.
measure.
Item 26.
Yes,
May I please, my lord?
26.
My lord, kindly have a glance to the read court order, my lord, running page number 11.
This is past contempt.
Yes, my lord, first contempt.
Past contempt.
So, my lord, what they are doing, my lord, your lordships.
What
protect-
was the direction in
Yes,
the
my lord,
read?
running page number 11, paragraph 3.
Yes, there is serious allegation
Against the public authority that while undertaking the exercise of measurement, the public authority is attempting to evict the petitioner without following due process of law. For the settled position that even an encroacher cannot be evicted without following due process
all
of law.
right. Therefore,
This is the Stitivan land of the petitioner. They are already
in the
taken.
meantime, what happened?
Yes, my lord. In the meantime, I have communicated the order. They have received the order on 3/3/2023 and 3/6/2023. Thereafter on 18/3/2023, they have dispossessed the petitioner. 43 decimal land upare, I have given the photograph at running page number 17, my lord. Taku gacha sobu katikina akasiya gacha kaja
Right, you want penalizing them in sending them to behind bar, or you want rectification of the order?
Compensation,
Huh?
compensation, my lord.
No.
Penalizing, yes, my lord. That is my first
If
priority.
you want sending him, I have no hesitation in issuing notice in contempt.
Yes, my lord.
But I can't restore your position in issuing contempt.
The second one I could not follow, my lord.
In the meantime, you have been dispossessed.
Yes, my lord.
Without following due process
Yes,
of
my lord.
law.
Yes, my lord.
I have directed any action subject to following process of law.
My lord.
In a contempt, how far this court can go? It may sentence him.
My lord.
Can your position be restored in a contempt?
My
So
position-
bring appropriate application again.
My lord, then my lord, restoration.
Oh, I am not there to advise you.
No, my lord.
I am not there to
No, my
advise
lord,
you.
in this case, my-
Sufficient indication I have given.
My
You
lord-
have to understood.
My lord, I will find.
I am issuing notice in contempt.
Yes, my lord,
Find
I
out
will-
other options available.
Yes, my lord.
Because your contempt cannot give you full relief. Issue notice in the contempt. Yeah.
My lord, may I
Requisites
pray for
as
a short
undertaken. Yes, 27 day. 27 day letter. Peruse the letter of the family judge. In the event, the
Item down of the 43. Item.
is peruse the letter of the family court. Flag B. This, okay. This court considering the request therein, observe in the event the proceeding declared to be disposed of within the time frame therein, if not disposed in the meantime, ought to be disposed of at least within a period of 2 months hence.
My lord.
Registry directed to communicate the decision of this court to the family judge.
My lord, interim application is 19, my lord, filed. And CP is filed on 2012.
No, this is
Till
the-
late interim maintenance.
That can be considered here.
My lord.
ଏଠି କାହିଁ କହୁଛନ୍ତି ଏଠି କାହିଁ କହୁଛନ୍ତି ଯୋଉଠି ଅଛି appropriate proceeding ଆଣନ୍ତୁ ଏଟା TRP dispose ହେଇସାରିଛି ସେ କରିପାରୁନାହାନ୍ତି ସାରି ପାରୁନାହାନ୍ତି ଚିଠିରେ ଲେଖିଛନ୍ତି ଆଜ୍ଞା ଆମକୁ ଆଉ କିଛି ସମୟ ଦିଅନ୍ତୁ ଆପଣଙ୍କ interim application pending decide ହବ ନ ହବ ମୋର ଆଉ jurisdiction ଅଛି bring appropriate application
Repeat number টা ভুল লেগে
ଏଟାରେ all right କରିଦିଅ appropriate correction is
Item 29.
Item 29, my lords.
Dear my lords, earlier it was dismissed for default.
କଣ ହେଲା hearing date ରେ ନଥିଲେ?
ମୋ ଖସିଗଲା ଗୋଡଟା ଖସିଲା ପଡିକି ରହିଲି ପିଲାମାନେ ସେଠି ମତେ ଧରିବାକୁ ପଳେଇ ଆସିଲେ।
ପିଲାମାନେ ବି ନେଇ ପଳେଇଲେ ଆପଣଙ୍କୁ
ନାଇଁ
ଦେଖିକି।
ସେଇଠି ପଳେଇଗଲେ ଶୁଣିକିରି ପଳେଇ ମୋ ପାଖକୁ ପଳେଇଲେ ଗୋଡଟା କରିଗଲା ଭଙ୍ଗା ଗୋଡ।
Response, sorry, valid response. In the non-appearance of the counsel and his associates on the listing of the matter on 29/3/23, this court find the CMAPL deserves to be allowed. In allowing the CMAPL, this court restores the OGC 1785 of 2001, which is also directed to be listed next week.
Item 31. 30 টা withdraw ହେଇଯାଇଛି my lord,
30 withdraw ହେଇଯାଇଛି।
Item 31.
May I please yours?
30 ଟା କେତେ କି 55 30
ବାହାର କରିଦେଇଛି my lord।
ବାହାର କରିଦେଇଛି। ଏଇଟା 31।
ଆଜ୍ଞା।
Okay, 31 is what is
31, ma'am. In the writ petition, the impugned,
why it has come today?
today, I have filed one miscase.
You have
So,
filed a miscase.
I have filed one miscase
For?
Now they have initiated, they have gone for proceeding with the to distribution of awards in favor of the awardees. So when the matter is pending before this honorable court and your honor, this honorable court has been pleased to issue notice to the opposite party, they have not filed their counter rate. And your lordship has already directed in the IA, in the main writ petition, that any
Conferment will be subject to result.
subject result of the
Yes.
writ petition.
What
So,
about?
they have filed, in the meantime, they have issued one notification in my IA, kindly have a glance, annexure B2 series.
Right, there can't be further stay. There can't be further stay. If you are agreed by such conferment, you bring amendment to the writ petition.
So
make them party, the party, they will be likely to suffering.
No, they are going to decide, they are going to award on 29th.
Yes, I have already made it conditional. Any conferment will be subject to result.
So let them file counter in the meantime, so that a matter will be
So
disposed
you
of.
don't press the miscase, or else I'll reject the miscase.
No, I am placing.
You are pressing already. I had the submission of the learned counsel in the miscase.
Undertaking ଯଦି any award ଯେ ଦିଆଯିବ ତାର undertaking ସେମାନେ କରିବେ।
23. This court find the petition is the issue involved herein is already considered in the hearing of the earlier miscase by it. IA 2456 of 23, and this court has already observed any action pursuant to the impugned order shall remain subject to outcome. Okay, for the interim order already there is no further interim order possible. In this case, the stand rejected. Yes.
Item 32.
I want to make a mention, my lord. I pray only 2 to 3 days may be granted to file requisites, my lord. To OP number 4, my lord.
Okay, requisites filed late be accepted and notice be issued forthwith. Yes.
Item 43.
May I please, your lordship? Your lordship, kindly have a glance to the last order. After hearing all the parties, your lordship was pleased to direct all the parties for a joint inspection of the property with regard to ascertaining the deviation alleged to have been made.
To ascertain the deficiency.
Deficiency. Now, your lordship kindly see, the previous deficiency report is annexed with in the counter affidavit B/3.
Now, presently the
present report is my learned friend has to submit. There are, my lord, serial number 22, 23, 42. We have complied with. In between, my lord. This report was of 24/20/23.
In between, ଯଦି comply kale, they will be taking a law
Again,
decision.
ସେତିକି ନାହିଁ sir, ଯେତେବେଳେ ଦେବେ, they have to see that whether I have complied with or not.
So your application for the registration is still pending.
No, it was refused on the ground that it violates the building.
Okay, then why don't
plan.
you, now that you have already complied, fine, detect.
No, so far as building condition is, the height of the building is concerned, it is pending before the city authorities, for which my lord.
That is also a condition required.
No, that is not required in view of Annexure 6. Those buildings which were carried on or were constructed prior to commencement of this act.
So you are showing other day the provisional registration
Provisional
can be granted.
Yes, ma'am. Provisional, I pray only that provisional subject to, my lord, that relaxation scheme also speaks that. It is debe, immediately within a particular period, I will provide the building plan. Rectified building.
These deficiency you have complied, where is the material?
Yes, my lord. You also kindly turn to the report. Report is, in the meantime, I have opened for exhaust of the smoke.
So where is that observation? Or your affidavit, at least you have complied. Oral submission.
That I have done, my lord. Subject to my lord, it is everything with them. Certainly, if I have not complied with, I am not entitled to that.
But Mr. Your application has already been rejected.
Yes, my lord. On the ground,
whatever may be the ground.
Sir.
Now that ground is no more sustainable remaining, because there is a fresh report.
Sir.
There is a fresh report. And you submit that you have already complied the deficiencies in the meantime. So therefore, why are you not making a fresh application? I'll give a direction.
Yes, ma'am.
You make a fresh application for registration or grant of license or whatever that.
But laws requires, my lord. Within 3 days they have to provide. Your lordship may indicate
So you
that.
make a fresh application.
Yes, but I'll make a fresh application.
Okay, following the previous direction herein, there has been an on-spot investigation in the presence of the petitioner as well as the other authorities involved herein. Copy of inspection report submitted to the court bears the signature of all participants, including that of petitioner. Even there is involvement of the assistant fire officer, Court of Fire Station. The Misra Learned Counsel appearing for the petitioner submits pursuant to noticing of deficiency in the report. In the meantime, the petitioner claimed to be already rectifying the defects. In such event, and for the grounds in the rejection order no more surviving, there needs a fresh consideration of the request of the petitioner in the matter of registration.
No, fire safety certificate.
In the matter of fire safety license.
Certificate. That is called certificate.
In the keeping in view the development taking place in the pendence of the writ application, this court permit the petitioner to bring an application, fresh application for consideration of the petitioner's case in grant of a fire safety license. In the event petitioner brings an application within 3 working days. 3 working days.
Your lordship may indicate 13.2. So rule 13.2, which says within 3 days they have to give. On the date of
you will submit within what?
Within by tomorrow, because it is an online application.
Undertaken by tomorrow. In such event, the fire safety officer shall do well in giving a lawful disposal to the same. Further also, keeping in view the provision
under 13.2 proviso.
13(2).
Rule 13.2, 13 within bracket 2
of the
fire safety rules. Fire safety rules 2017.
2000
Odisha Fire Prevention and Fire Safety Rules 2017.
With this observation, okay, in the working out, fresh working out, the observation, if any, in the made in the previous rejection may not be influencing.
With regard to fire safety only, building regulation, they don't have power.
Fire safety, I have only directed, and I have directed the fire safety officer only.
In this report, they have pointed out the deviation with regard to height of the building. You also kindly see in this report, they have indicated the height of the building is also one of the deviation.
Yes, because that deviation is still there.
That if it is protected, then he will consider.
That your lordship may indicate, because they
Why should I
say
indicate it? You were other day referring to that document.
Annexer 6, your lordship specifically directed.
That's why I said any observation in this
So-
regard in the previous occasion shall not be
It
influenced.
requires adjudication, because Annexer C, they say, it is not applicable to me. I have not availed it. Though their counter affidavit says that I have availed it. I
Place-
pointed out.
You place those reliances.
But they say,
You can quote that person in the counter affidavit.
yes, Milord,
So therefore, it may not be any further
your lordship may
necessity.
indicate that. That will create confusion. Annexer 6, I have,
That's
your
all,
lordship can-
that's all, Mr. Mishra. Yes, next. Yes.
Deviation the building is 2019 sir chali galani seta.
Yes, next.
For
next.
addition item 33.
Is anybody there? Nobody appearing for the petitioner. Matter is pending since 2007.
33.
Dismissed for non-prosecution.
33.
Council for Development Authority is present in court. Yes, our case study, Sonok Misra, Dayanand Mahapatra, so Rohi Varna. Yes, 34.
34 may payment taken up next week. 34 please to take
How next week, how many after vacation, Joe?
No, Lord, there is an interim order. It has come on our mentioning. In fact, Milord, it is covered by your lordships that Dilip Barar advertised location was the issue. He has offered a land in Milord. It is last week, I think, on
my friend my lord started arguing, but
Yeah,
in fact
possible
No, that's correct, but it's a 2015.
my
there
friend
a
is
stay
arguing that
against us.
there is an interim order pending. I pay my taken
That's
up next
correct.
week because I don't
Interim
file
order is
it.
against
Based on
us.
the
That's
file, I
why we
want
have
to-
made it a mention, and it has been on our mention, it has been listed. Milord, it's covered by that Dilip Ball's case. Last week, your lordship
Dilip Bal
decided
case, I don't.
What do you want?
advertise.
I pray
local
next week any day, my son, because I couldn't
He
accept
has
the
offered
file
a
today,
land
but
in
that is what I
Vincha.
pray for.
I pardon my lord. I am for the OP, my lord.
Place the matter next Thursday. Okay.
Interim order to continue.
In the meantime, say Mahapatra.
My lord, I am for the
see
opinion, lord.
Mahapatra examine the judgment in so and so sought to be covering.
Dilip Kumar Ball versus IOCL.
Achhi, am pakhre achhi
WPC
copy.
number. I'll serve a copy on my.
Am pakhre achhi copy, ote copy deyi diyantu taku better.
I'll serve.
Pardon, my lord, I am for
Interim order to
the
continue.
In this case, I am for the OP.
Interim order to continue.
Interim order to continue.
Pardon, my lord, I am for OP in this case, my lord, OP3.
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 Samastha na lekha haba besto.
Copy may be served.
Ko copy debe?
Plain copy also.
Petition copy paina
Nahi.
Hey, this is old matter, 2014.
Yeah,
Must have been
inter-
served notice. Diyantu ba, kotha hai ki nahi jantu, copy te deyi diyantu. Yes.
Item 35.
May I please, your lordship? This case, my lord, then is required to be disposed of, my lord, by your lordship's previous orders at page 189. In earlier writ application, my lord, your lordship's disposed of that, which was against the same impugned order of the Lokpal, my lord, Lokayut, my lord. Your lordship directed that since full opportunity to be given, there will be no question.
Just 1 minute. I can't take up all these hearings. This
No,
is
it's
a
a-
hearing matter.
It's a simple matter. I'll
22
explain, my lord.
22 matter. Mr.
I'll
Mishra,
explain, my lord.
sorry.
I'll explain. It will just take 1 minute. He's
No,
also
you may
agreed.
take 1 minute, he may take half minute, but ultimately I am to deliver.
One co-accused came before your lordship. Your lordship passed an order. Same council, another co-accused went before another division bench, and there is a stay order which is not in sync with my lord's order. So since it arises out of the same case, my friend is also agreeing. He's for the petitioner.
Yes, but it can be
the
disposed
same
of.
order can be passed. So it's not on. We are not entering into contest here.
189 page.
Division bench has disposed the matter.
No, single bench. What has happened here?
Another single bench has disposed.
Has entertained this writ and has stayed the operation of the order. Whereas my lord didn't entertain and said that these are prima facie views. So now it is a case where one co-accused gets one order, another co-accused through the.
There may be difference in the action of these.
No,
people.
same order.
Same order can such.
What to do then?
But if
my
you
lord-
actually look at page 189.
My lord may
Page
see,
189.
my lord's own order.
Therefore, hearing is necessary, Mr. Mishra.
This writ petition is covered by my lord's own order, disposing of the writ.
If he agrees, then I will
Yes,
pass
sir.
that
He's
order.
agreeing.
He is agreeing.
Yes, sir.
Yes.
Where is my order then?
Page 189, madam.
Page 189. In my,
In the second counter, my lord, page 189.
189?
Yes, ma'am. Because there was a threat of the disciplinary proceeding and the criminal proceeding.
yes,
So your lordship granted that liberty, my lord, that in the event he will be given fullest opportunity. So in that way, the matter.
That's an interlocutory order only.
no, my lord disposed of the writ.
Yes, ma'am.
Order dated 26/4/2020.
189?
Yes, ma'am.
In my,
9184 of 2022.
Oh, yes, yes.
Para 3 months, your lordship disposed.
So same order will be there?
Same order.
Yes.
All right, for the 189 रे जो order ଅଛି ହେଲା खाली council को ना बदलिबो एटा होछि आप अपील करछन्ती का पई
For the petition, my lord.
सुशांत कुमार मिश्र को पई
Yes, ma'am.
नुआ वकालत दैछन्ती?
Yes, ma'am.
Okay, there is a substituted appearance by Sri Tripathi, Bhavani Shankar Tripathi. Had the matter involving Sri Bhavani Shankar Tripathi and Sri Gautam Mishra Senior Advocate, assisted by D.K. Patra.
by A.K. Das.
A.K. Das.
A.K. Das.
Mr. A.K. Das. Yes. A order 26/4 page 89 रे जो order ଅଛି से order करतो होला.
This writ
All right.
can be disposed of, interim order may be vacated.
Yes, for the disposal of the proceeding, interim order stand vacated.
We are grateful.
Lot of matters are pending for correction.
My lord.
So I don't want to take any other load for again dictation.
No, since it's a short matter, we had made a mention.
Item 36.
36, my lord, I require some time, my lord, because they have filed an affidavit. Compliance affidavit.
After vacation, after vacation.
Well, I'll file my objection to that.
Yes, pleading if any, we brought in the meantime.
Well,
Item 37.
time.
37, man.
After vacation.
After vacation, my lord, some.
After vacation time चाहूँचंती.
Well,
All right.
because it is your lordship's order, my lord.
हाँ ठीक है चला.
Item
8th of September. 8th of September. I'll be demitting by 6th.
July.
6th is a holiday. God is so kind enough. मोरो retirement रो 2 दिन आगुरु छुट्टी कर देइछन. I'll be spending 2 of my working days at my next.
Item 37.
Please, lordship. In view of the counter, my lord.
एथरे other side को ना भी लिखी दो वाला. Yes.
My lord, in view of the counter, my lord, this matter is not infructuous, my lord, this matter.
Okay. Counsel.
As per
counsel appearing for the petition as a fair submission. After the counter statement, the matter has gone infructuous.
Para 7, para 9 of the counter.
Para 9 of the counter. Proceeding is accordingly dropped.
Obliged.
My lord, sub item 3, my lord, WBC number 471. I am for the petitioner, my lord.
Sub item 3 कौन हला?
1 week time to file rejoinder, my lord.
So second matter भी infructuous है गला? Second टा भी infructuous है गला?
I am not.
There are 3 matters.
Yes, my lord.
I am 32223, my lord.
Okay, सरला.
Yes, my lord.
Then 471 किया अछंती?
I am for the petitioner, my lord.
Okay, you say third matter will be. Say एटा कौन कहउछंती?
1 week time to file rejoinder affidavit, my lord.
You want to file rejoinder?
Yes, my lord.
Okay, all right. Matter is taken out of the list ला.
Obliged, my lord.
Next third matter किया अछंती?
It's modi का second matter टा से तारो.
3टा matter अछि.
हां सेटा last टा से कह देला.
3674 रे किया अछंती? Nobody is present. Allah dismissed for non-prosecution. Third matter. Eta. Okay, this one. Yes, next 38.
Item 38. 38, my lord, I pay for the next week.
Next week, after vacation.
No, my lord, next week, my lord.
आउ एबे किछि रखिबिनी सब को बहुत मैटर ए छुट्टी भीतर नेबी बोली डिसाइड करछि therefore let me find wherever
Yes, my
councils are ready those matters will be
pleading completed. They have also filed the counter and I have filed all the rejoinder, my lord. That's taken up today, my lord. 39. My lord, taken up today, my lord.
Next.
Ma'am, today taken up today.
सब अर्जन अब व्यस्त होतुनी.
Item 39.
I'll not take up these 23 matters now.
Item 39.
39 will also be after vacation.
Also, item 39, I have a small submission
Hmm.
that Arunodaya Market Complex CD office where they are running, a part of that was laid out minors to the petitioner. Now, minors, the authority decided to demolish this and to undertake a new development. That is what we cancelled it. We also require the petitioner to cooperate so that he can take back his whatever amount earnest money he deposited with interest on all these things. That is what, that is the very important part is that I filed a counter, my kind of glance to the counter. We already,
So who prevented you? I mean, the order kar deyithulu, any action will be subject to
yes, ma'am, that is there. I'm processing arama koloni. Processing arama kola pare kono hochi ki the problem will be that suppose they will success that some order will be passed that may be prejudiced. That is what the keeping in interest of all.
It has to be finally disposed. That's
all right, man. That's the only thing that I'm to proceed, my lords, in accordance with my lords.
Proceed, but unless I clear the matter,
Yes.
otherwise by virtue of interim order, if you can take.
All right, man, all right.
After vacation.
Yes. Interim order to continue.
Interim order to continue. Interim order is open order. You can take.
All right.
Further order to be.
नहीं interim order टा कौन absolute है जी हाँ ये dispose है जी it's a final order.
Final order.
Yes.
Subject to result of the case.
Any action subject to result. अब vacate कर दो ना जी से development में कोई चंद
नहीं बहुत जिंस अच्छी था भीतर
नहीं जाओ
फाइल रिजॉर्डर में
नहीं जाओ ना ती
नहीं जाओ
अपन नहीं जाओ ना जिंस सुनो तो if you want you can't continue they have a different design they will undertake some construction there ये घर भी सब एगुडा कोदिन
ऑलरेडी नष्ट हो गया
5 वर्ष लागे मु मते दउ ना ती
जिंस नहीं जानते in the meantime I'll further interim
take instructions my lord in that regard your interim order टा थाउ
interim order but gives leans in their favor. So they can throw you out even. It is better you make an application, take your luggage.
No, yes, ma'am. No application. Let him appear on a particular date. We will hand it over.
He is considering there is further development required in demolition of the building. In the event petitioner applies for taking out its material, same shall be allowed. Yes. Take out, thereafter we'll decide.
Interim order to continue.
Our interim order to finally interim order to continue.
Item 40.
Kindly have a glance to your lordship's last order. On my interim application, lordship has directed to take instruction specifically. I am continuing and managing 2 public health centers since 2010. Lordship has been pleased to issue notice to the no, they have not filed the counter. Now what happens? They are going to engage the opposite party number 5.
What is that?
I have filed the interim application in shape of affidavit.
How can that be interim application unless amendment is brought?
No, what happens? I am continuing.
New cause of action or not?
Yes, ma'am. That is why I have filed
If
this
it is a
interim.
new cause of action, first bring it within the fold of the writ petition, then only interim order.
During filing of the writ
Not
application,
there.
I am not.
Sorry. Interim application is insisted on the basis of a new cause of action. For the opinion.
No, my lord, in the writ petition, they have decided to to engage the opposite party number 5.
My lord, I am
But they did not proceed.
for opinion.
They are proceeding.
I am appearing for opinion number 5.
Number 5.
Yes.
And a glance for a
But
moment.
no order is past date.
One by one.
Page 40, my lord, for a moment. My writ petition for page 40.
Yes.
Last
40.
Last portion, my lord. Now, therefore, in view of the above, the representation of a New India Agency, my lord petitioner, is duly considered in its true perspective, and the claim of New India Agency is hereby rejected, and the scores awarded to CORAM opposite point number 5 by the district NGO committee stands. Necessary communication in this regard shall be made to CORAM regarding award of management of Dadraghati Public Health Center and Khokira Public Health Center in PPP, Public-Private Partnership.
So there is no new miss case.
No.
There is no new miss case.
No, my lord.
You said there is a further course of action.
No, my lord. I am sorry. So I press status quo to be maintained. Let them to file counter.
And my lord,
What is your position? Have you taken over?
no, my lord.
No order has issued to us also.
That is
They
admitted.
have not taken a decision at all.
Yes, you are not
Status quo.
filing counter, let the status quo be maintained.
My lord.
Lordship may call it next week. I'll take instruction, my lord.
Next Tuesday, on the request of State Council, who is directed to take instruction on the running of the institution as on date by next date. Yes.
My lord, one more thing I can point out to your lordship. This is a tender matter. And your lordship see the judgment he has quoted, that is from a division bench. But how could it be listed here? Your lordship see they have quoted the judgment. There's a division
No,
bench.
no. What is the issue involved?
Issue, my lord, management of a public health center by
There is-
NGO.
So
There is
there
a
is a
ten-
question of tender here.
Yes, ma'am.
No, where is the question of tender?
There is a tender for this. To who will manage the?
See, he came in a writ application, there was a direction for disposal of the representation. Now this is rejection of a representation.
But-
Sorry, all right, you reserve your ground, you can take it at the final hearing. Yes, next.
Item 41.
41 ଛୁଟି ପରେ ଆସିବ।
Third party transfer ଟା refuse ହେଇଛି।
Third party transfer counter file କଲେ?
ହଁ, କରିଛନ୍ତି ସେମାନେ। My lord, one thing I will submit before, after your lordship,
hearing ହେଇପାରିବନି ଆଜ୍ଞା।
ଗୋଟେ line ରେ କହୁଛି, after your lordship has tendered has pronounced the judgment, my lord, relating to single quota discretionary, relating to single allotment discretionary quota, my lord, those persons are to be seen as a general category, my lord. The benefit which the general category are getting, these persons are also entitled to get, my lord.
So therefore, there needs a final outcome, madam. Let me decide, these are not small issues.
No, your lordship has already,
ମୁଁ ତ ଦେଲିଣି 4ଟା 5ଟା ଜଜମେଣ୍ଟ ଦେଇ ସାରିଲିଣି, ସେ ସନ୍ଦେହ ନାହିଁ, but the other side if says covered, then I can dispose. They will be contesting.
no, खाली ଆଉ ଗୋଟେ line କହିଦେବି।
ସେ contest
After your lordship passed the judgment, the government has issued a notification. That notification creates the problem, my lord.
creates the problem, then I am to resolve. I am to resolve.
Not
I am to resolve the problem
not in consonance with your lordship.
by a judgment. ସମୟ ଦିଅନ୍ତୁ ହଉନି।
ମୋର anxiety ଟା ଆଜ୍ଞା ଗୋଟେ ପାଇଁକା। Your lordship knows that.
ଆପଣ ମାନେ ଆମ anxiety ବି ବୁଝିବା ଦରକାର ନା।
May I request, my lords, in this case, the government made a circular admittedly contrary to the decision of the Hon'Ble High Court. So government in GA department should file a counter in this case.
If they so like, who can bring them to file counter? They are party already. Yes, you advise your client accordingly. Mr. Mishra, you advise your client accordingly. Ultimately, circular is in challenge.
ନାଇଁ ମୁଁ circular ଚାଲୁ ନାହିଁ। Previously ମୁଁ ଆପଣଙ୍କ judgment ଅନୁସାରେ dispose of କରି ନେଇଗଲି।
Okay, they are not agreeing.
ନାଇଁ ସେଟା ନେଇଗଲି, ସେଟା କହିଲେ single quota ତାଙ୍କର କରିବେ ବୋଲି। ସେମାନେ without following your lordship judgment, ସେ government circular କରିକି ମତେ reject କରୁଛନ୍ତି।
That's right. There is a government circular intervening.
After your lordship
So
decision.
Examine kariya kabo.
After your lordship decision, my lord.
Yes, 42. After vacation.
Vacation ଗୋଟେ କୋଉ date ରଖୁନାହାନ୍ତି?
Third week of the after vacation.
Item 42.
My lord, I am appearing for the opinion number 5, my lord.
Ye bhi election matter.
My name has not been reflected, though I had
Election
filed my.
matter ବର୍ତ୍ତମାନ ମୁଁ ଶୁଣିବିନି ଆଉ. Interim order to continue after vacation.
My lord, my name may be reflected in the cause list.
Yes, name ବାହାରିନି କି?
But in the last occasion, I have filed my vokalatnama.
କଣ ହେଲା କାହିଁ ବାହାରିନି? वकालतनामा ଅଛି?
And my lord, in the court I had filed.
କାହା ପାଇଁ ଆପଣ ଲକ୍ଷ୍ମୀପ୍ରିୟା ବେହେରା ପାଇଁ appear କରୁଛନ୍ତି?
My lord, opinion number 5, my lord.
Sanjay Kumar Patnaik and
My-
Associates. Okay, registry directed to indicate name of Sri Sanjay Kumar Patnaik and Associates, who have already appeared for UP number
5, my lord.
5. All right. Hello. In the next listing of matter, interim order to continue. Yes.
Interim order to continue.
Interim order to
My lord,
continue.
next week, my lord.
Item
After
44.
vacation.
Item 44.
My lord, I appear for OP number 5 today, my lord. I will file counter.
23 matter.
OP number 7. my
Yes, so what do you want? You want to file counter?
My lord.
Who is for petitioner?
Lordship, I am
You
for
are
the.
there, okay. There is recent appearance on behalf of the. ଆପଣ ସମସ୍ତେ ଜଣଙ୍କ ପାଇଁ appear
I am
କରୁଛନ୍ତି?
for OP number 7.
7, you are for?
Pollution Control Board. OP number 5. OP number 5.
There is recent appearance on behalf of OP 5 and 7. Both the sets of counsel, Sri Mahanti and Sri Shant, appear claims for filing objection. Place the matter July 2nd week re karibo. Response if any be filed in the meantime.
Interim order to continue.
Interim order to continue.
Deeply obliged.
Yes, next matter after vacation.
I am for the petitioner. I am, there is an interim order.
ये counter file हेलानी?
Election.
Counter भी नहीं.
Election matter, your lordship. Counter need not be.
Election matter.
My lordship.
So after vacation.
Date कल ही था. Date कोटा ही था आपको पाखरे.
आसो मो retirement पर.
नहीं आएगा नहीं नहीं.
नहीं आगे आपण तो सबू मो केस रे नहीं करी रीट अपील रे पोजीशन
सबू जाई नहीं आएगा. को कोटा दिन जाई थी भी सबू केस रे मु आगे ऑर्डर नहीं.
ना